Good morning. I call to order the public meeting of the Commodity Futures Trading Commission to consider issues relating to the trading of futures and binary options based on motion picture box office receipts. I would like to start by thanking today's panelists, my fellow commissioners, the CFTC staff for being here today. This is our fourth public meeting this year, and I hope to continue, as I know that my fellow commissioners do as well, these public meetings to consider important matters before the Commission. I wanted to pause also and just give a thanks to the staff of the CFTC and the staffs of the SEC in putting out a joint preliminary set of staff findings on the events around the market events on May 6th. They've worked tirelessly. The cooperation between the SEC and CFTC was really what you would hope for from public servants in this nation. And it was reams of data, and there's still much to do in the future, but I just wanted to pause a moment and thank the staffs here and at the SEC for that. Last month, the CFTC approved the applications of Cantor Futures Exchange and media derivatives for designation as contract markets. The Commodities Exchange Act requires the Commission to approve such applications if the applicant meets criteria that are enumerated in the Act. Given the novel nature of the contracts that the Cantor and MDEX have proposed trading, however, the CFTC requested, and both of the designated contract markets agreed, that all new classes or category of media-related contracts that these contract markets plan to list must be submitted for approval to the Commission. This is actually in distinct contrast to how most futures contracts on existing contract markets can be self-certified in one day. And so that's why we're seeking to learn more information here. Today we'll hear from the views of 8 panelists on whether the Commission should approve the Cantor and MDEX first contracts or deny those contracts. The Commission actually will not vote today, but the purpose of the meeting really is to allow the commissioners and the public to learn more about these contracts. We are interested primarily in fact-finding. And given the interest that the public has expressed in the particular contracts, we thought together that it would be good to have a public hearing. It's the most transparent way to do this. It's also most efficient for the 5 commissioners, rather than have individual meetings with various parties behind closed doors. So the Commission and the public will hear from 2 panels. Both Cantor and MDEX are here. We chose to ask one to be on one panel and one to be the second, just to spread that out, but we also have a number of other parties that will be speaking to us. Before we do that, Rick Schiltz, who's the head of our Division of Market Oversight, hasn't gotten a lot of sleep these last 10 days, Rick, so I thank you particularly for pulling together some thoughts here. We'll go through and present the actions taken so far by the Commission with regard to Cantor and MDEX's application and some of the statutory considerations. We've asked our General Counsel, Dan Berkowitz, to sit at the table in case there are questions. But also, the record for this morning's meeting will stay open, I think, till May 26th. My, 1 year since my swearing in. Huh? Instructions for mailing the comments can be found at our website, www.cftc.gov. Comments can also be transmitted by fax to 202-418-5521 and emailed to us. All comments received and a copy of the transcript of the hearing will be on our website, and all of the testimonies today, of course, can be brought by, seen by live webcast. Before I turn to Director Schiltz, each of my commissioners will have some thoughts to share, and I turn to Commissioner Dunn.
Thank you, Mr. Chairman, and an interesting year it has been for you as well. Predicting the success or failure of a futures contract is possibly more difficult than predicting whether or not a motion picture will be successful. Most new future contracts fail. An estimated 70 to 80% cannot attract and sustain a profitable level of trading volume. Despite the fact that creating successful and sustainable futures contracts appears to be against all odds, exchanges are continually working to bring new products to the market in hopes of finding successful contracts. Future contracts based on the box office receipt are new products. I applaud the new exchanges that have created these innovative products and look forward to hearing what they have to say, particularly how their contracts would be useful to the market and how they comply with the Commodity Exchange Act. I understand that box office contracts have also caused some in the motion picture industry to raise objections to their trading, noting that contracts will not be useful and are susceptible to manipulation. I am very interested to hear the evidence that supports these assertions. In determining whether to approve new contracts for trading, the Commission is bound by the rules and regulations set forth by the Commodity Exchange Act. Staff has worked very closely with all interested parties regarding these contracts, and I await their recommendation on whether or not they should be approved for trading or violate the Act in some way. Until that time, I will keep an open mind on this subject and look forward to listening to today's panelists, and I want to thank all of you for your participation.
Thank you, Commissioner Dunn. Commissioner Summers.
Mr. Chairman, last month the Commission approved the applications of Media Derivatives and Cantor Futures Exchange to become designated contract markets, conditioned on a requirement that the exchanges will submit all new classes or categories of media-related contracts for approval instead of using the self-certification process. We imposed this condition due to concerns regarding the nature of the contracts IMDEX and Cantor initially intended to list for trading, which are based on motion picture box office receipts. There are a number of questions I have regarding whether these contracts can serve as a useful hedging tool, how they will be settled, and whether they are susceptible to manipulation. As I stated in my concurrence to the Commission's approval of the Cantor application, I also have an overarching concern as to whether the contracts these DCMs intend to list for trading raise broader policy issues related to information aggregation markets. 2 years ago, the Commission published a concept release seeking comment on the appropriate regulatory treatment of financial agreements offered by markets commonly referred to as event, prediction, or information markets. Commission staff has received numerous requests over the years for guidance on types of contracts that should be allowed in this category. Unfortunately, the Commission has not yet established a framework for resolving this issue. I would prefer that the Commission address the broad policy issues raised in the concept release rather than approving or rejecting requests to establish information markets on an ad hoc basis, which is where we find ourselves now. That being said, our governing statute and regulations require us to act on requests for approval of contracts within a specified time frame. The deadlines for the IMDEX and Cantor contracts are fast approaching. Section 5cc of the Commodity Exchange Act mandates that we approve these contracts unless we find that they violate the Act. We have no discretion in this regard. Based on the record developed so far, I do not yet know the answer to these questions, and hopefully the information we gather today will assist us in making appropriate determinations. I thank all the panelists for being here today, and I look forward to hearing their testimony. Thank you.
Thank you, Commissioner Summers. Commissioner Chilton.
Thank you, Mr. Chairman. Since you commented on the study, I just want to say I associate myself with your remarks, but I also was thinking about this amendment that came up last night that concerns me on regulatory reform. And let me actually give a little bit more to the chairman. I mean, this bill, I think, was stalled significantly on the Hill, and in no small measure, Gary Gensler has helped move it forward. And he's done a lot of behind-the-scenes work, and the staff has done a lot of behind-the-scenes work that's been critical. I'm not 100% sure it would have gone forward without your work. So we're in agreement on a lot of these issues, and I thank you. I don't know if we're in agreement on the Dodd amendment that I saw last night that concerns me greatly, and that's for a 2-year delay and a study before they would implement the OTC provisions. If there's anything we've learned from the financial calamity, it's that getting a view into these dark markets is critical for consumers. So I really appreciate the bill that Senator Lincoln and Senator Dodd have come forward with. I want to see it passed, and I want to see it passed now. So, on this issue, want to commend the Cantor folks and MDEX folks and for coming up with something that's neat and novel. And in general, I hate to be, a guy a regulator that holds back innovation, because I think it is pretty cool. And we all have sort of a common experience of sitting in a movie theater, maybe before the film, and being treated to or subjected to various previews and over your popcorn. And, oh, that's neat, or I want to see that, or you couldn't pay me to see that, whatever it is. And so I find it sort of cool in general, but I'm not sure that cool means it's a business, although I'm open to looking at it. These are critical markets, if we've seen in the last couple of years and since May 6th, and they're important. They discover pricing for consumers, and these are really serious markets that we work on every day, and sometimes all day, every day, and all weekend. So I'm not making light of them, but I want to make sure that they pass the legal test, which is what, no matter how cool or neat one of us might think it is, it's got to pass the legal test. And in that regard, I'm concerned about three things, and we'll be talking about it today. I'll be talking about it today. What is the underlying commodity? Are these subject to manipulation, and how would we surveil those that can have an impact on it? And is it a viable hedging mechanism? Is it a viable hedging mechanism for the folks who would be most affected by this? I mean, if it's not a viable hedging mechanism, we can't approve it. That's sort of the core of our act. So I look forward to that. I also want to commend the chairman for the transparency in general. Having these meetings, I think, is very good. It adds sunshine. And in that vein, not for now, but whenever the chairman feels comfortable, I would like to have some sort of comment on. I'd like some transparency on this vote. I'd like to make sure that people will know about the vote or the seriatim when it occurs. So we don't have to do that now, but whenever it's appropriate. So with that, I thank you all for being here. Appreciate your time, and again, appreciate the work of the staff. Thanks, Mr. Chairman.
Thank you, Commissioner Chilton. Thank you for that kind remarks. I'm thinking, Dan, if you can direct with your little BlackBerry somebody to look at this amendment that Commissioner Chilton mentioned, just to see what it says. I know it was reported in the newspapers, but thank you. Commissioner Amalia.
Mr. Chairman, thank you for calling this hearing. I appreciate the participation of our witnesses on this panel and the other panels. Today's hearing will give the Commission the opportunity to learn about a potentially innovative product in the film industry. This industry has advanced at a rapid pace to bring us technological wonders like Avatar, and at least two entities are trying to innovate the way movies are financed. I intend to use this hearing to better understand whether or not these contracts fit into our regulatory scheme and if they meet the core principles mandated by Congress. While there's no statutory requirement that these contracts be universally accepted, I'm also curious to learn from our witnesses whether they believe these contracts will be effective in managing commercial exposure. Innovation in both technology and financing is inevitable, and as regulators, we must stay on top of the way markets innovate. I'm very pleased that the Commission will vote this week to reestablish the CFTC Technology Advisory Committee, especially given the market events of May 6th and the integral role that technology appears to have played in those events. Technology is now the foundation of the derivatives industry. Market information, trade strategies, and execution, risk management, clearing, and settlement are all dependent on technology. In our time, we have seen an unprecedented shift from trading in physical pits to trading in the virtual pit that spans the globe 24/7. Unfortunately, here at the Commission, we struggle to keep pace with the technological advances as we continue to receive account data via facsimile and enter data manually. I fully expect that Congress will provide new authorities to the Commission to oversee the OTC markets, which are estimated to be 10 times the size of the regulated markets. This agency is about to be hit with a tsunami of trade data, and the fax machine will not provide any assistance whatsoever. We must do a better job to automate all our forms and systems to handle the massive amount of data that will be sent to this Commission under the new authorities. As regulators, we must understand and embrace technology in order to be effective. The Advisory Committee will bring together the best and the brightest to discuss how technology is being deployed across the industry, how the CFTC should oversee such technology, and what the future holds for technological advancements in our markets so the CFTC can stop playing catch-up for as long as it has. The committee will include representatives from academia, exchanges and clearinghouses, trade repositories, or technology traders, otherwise known as algorithmic and high-frequency traders, FCMs, end users, and banks. The committee will hold its first meeting hopefully on July 14th, which will specifically focus on high-frequency trading. The hearing will include a presentation from the Office of the Chief Economist on recent research into high-frequency trading, including a model that shows how these high-frequency traders affect the market. Other hearings will address co-location, automation of CFTC data, trade repositories, swap execution facilities, and technological surveillance and security systems, just to name a few. Members of the committee will be expected to provide papers on a number of topics so the committee and the commission can have informed discussions on these important issues. I look forward to convening this hearing in the near future and for the committee to for this committee to make a valuable contribution to our technology debate.
Thank you, Commissioner Amalia, and I thank you also for your leadership since you've come here on reestablishing the Technology Committee, because I think it is a big plus to this commission and this agency.
Well, let me just say, I know that everybody has had a role in this, and this was not a hard sell for anybody on this commission, and I appreciate your support of that.
No, but it usually takes one person to pick up the ball and run with it, so thank you. With that, Director of Market Oversight, Rick Schultz.
Thank you, and good morning. As you noted, the purpose of this hearing today is to provide the Commission with additional information related to pending contract approval requests submitted by two exchanges, Media Derivatives, which I'll refer to as MDEX, and Cantor Futures Exchange. The settlement prices of the contracts submitted for approval are based on the level of box office receipts from theaters for particular movies. These contracts are often referred to as movie futures or box office receipt futures. As Chairman Gensler noted, the designation orders for both MDEX and Cantor require them to submit to the Commission for prior approval any new class or category of media-related products before listing them for trading. In conditioning these designations, the Commission recognized that media contracts may require special review to ensure, among other things, that they are consistent with the Commodity Exchange Act and the Commission's regulations, considering the unique nature of these contracts. On March 9th, MDEX, or Media Derivative, requested approval of its collared futures and binary option contracts based on the open weekend motion pictures revenues for the film called Takers. A collared futures contract is a contract that caps each trader's possible gains while limiting potential losses. The caps and floors will establish trading ranges of $100 million, with each $1 million of revenue equal to $50. For example, MDEX can list a contract for Takers that has a floor of $200 million and a cap of $300 million. If a buyer and seller enter into a contract at an initial revenue of $250 million, then the seller would collect $2,500 from the buyer. This figure is arrived at by subtracting the floor, $200 million, from the initial contract value, $250 million, resulting in a revenue level of $50 million. Since each $1 million of revenue is valued as $50 as set by the exchange, the initial contract value would be $50 multiplied by 50, or $2,500. If the actual gross box office revenues for the film are below $200 million, then the buyer would lose $2,500 and no more than $2,500. The purpose of the cap and floor is to ensure that maximum gains and losses are known in advance so that the contracts can be fully collateralized. With respect to position limits, MDEX has proposed a position limit of 25,000 contracts, net long or short, for its Takers collared futures contract. MDEX also intends to list binary call options with strike prices of $20 million, again based on that same movie. A binary call option contract is an option in which the purchaser either receives nothing or receives a fixed amount if the box office receipts are at or above a specified strike price. An option is in the money if the opening weekend picture revenues are greater than that strike price. The value of an in-the-money option would be $5,000. For that contract, MDEX has proposed a position limit of 25,000 contracts for all strike prices combined. Both MDEX contracts are settled based on the reported opening weekend motion picture revenues. The opening weekend is defined as the time that the motion picture is released to the following Sunday. The contracts are then settled on the following Thursday. The MDEX contract's 45-day fast-track review period would have ended on April 23rd, but staff extended its review to the full 90-day statutory review period. The statutory review period ends June 7th, 2010. On March 30th, Cantor requested approval of its domestic box office receipt futures contract based on the movie The Expendables. Cantor intends to list futures on domestic box office receipts covering revenues for the first 4 weeks that a motion picture has been released. The 4-week period is defined as the time that the motion picture is released through the 4th weekend following release. The contract size is determined by dividing the box office receipts number by $1 million. Therefore, total box office receipts of $100 million would translate into a contract size of 100. For this contract, Cantor has proposed a position limit of 10,000 contracts. As I noted with respect to the MDEX contracts, staff also extended the review period for the Cantor contract to the statutory deadline, which is June 28th. The box office receipt numbers used for cash settlement for all these contracts are calculated by the distributor of the motion picture. Staff understands that the vast majority of motion picture revenues are reported from the theaters to distributors through Rentrack Corporation. Rentrack is a media measurement and research company that, among other things, provides audience measurement services to the entertainment industry. It is essentially a third-party data aggregator and has no direct interest in any particular motion picture. A small amount of box office receipts are not reported through Rentrack. They are reported directly from the theaters to the distributor. This data is referred to as call-around data. Once the distributor sums the Rentrack and the call-around receipt data, that number is reported back to Rentrack, which in turn distributes it to Variety Magazine, Box Office Mojo, and other news organizations and interested parties. The exchanges have created processes to validate the gross box office revenue data disseminated by the studios that will be used to calculate the final settlement values. The objective is to ensure that the Rentrack raw data comprises a very high percentage, that is usually about 98%, of the gross box office revenues that are reported publicly by the distributing studios. If publicly reported data varies from the raw data in a manner that is statistically significant, the exchanges will initiate additional procedures to validate the data, the Rentrack and call-around data. Both of the contracts, or all 3 of the contracts, have been posted on the Commission's website for public comment. The comment period for the MDEX contracts ends on May 14th. The comment period for the Cantor's contract ends May 21st. As of yesterday, 5 comment letters relevant to the contracts have been submitted. 2 comment letters were from members of Congress, one dated April 22nd from a group of senators, and a second dated April 28th from a group of congressmen. Both of these letters expressed concern about the CFTC's possible approval of movie box office revenue contracts, citing pending financial legislative efforts that may prohibit such contracts, the opposition of a segment of the movie industry to the listing of these contracts, possible trading restrictions on studios, and whether such contracts can serve as a hedging function, and the possible diversion of CFTC resources. The other comment letters were written in support of these contracts. One commenter stated that the success of the contracts was critical to fostering growth in the U.S. film industry and in creating efficiency and transparency in the financing phases of films, while another letter stated that support for regulated and transparent box office receipt futures exchanges. With respect to our review, the Commodity Exchange Act specifies that the Commission must take action on a proposed contract within 90 days of its request for approval. The relevant provision particularly provides that the Commission shall approve any such new contract or instrument unless the Commission finds that the new contract or instrument would violate the Act. If no action is taken at the end of the 90 days, under Commission regulations, the contract is deemed approved. Under the Commodity Exchange Act, the primary focus of staff's review of new contract filings is to ensure that the contract is not readily susceptible to manipulation, Core Principle 3, and that the contract has speculative limits or position accountability rules that would minimize the susceptibility to manipulation, that's Core Principle 5. In addition, staff considers any comments received related to the approval request. Under Core Principle 3, for cash-settled contracts such as these, staff carefully evaluates the cash price series that would be used for cash settlement. In particular, we will consider the manner in which the Rentrack number is generated, the data calculation methodology and data release procedures, the mechanisms and procedures in place by Rentrack and the distributors to ensure its reliability, that it's not readily susceptible to distortion or manipulation, and the specific rules and procedures adopted by the exchanges to mitigate against manipulation and inappropriate premature access to the numbers. Also, as a part of this review, and pursuant to the provisions of Guideline Number 1, which relates to new contract approvals, staff will consider whether the box office receipt revenues are reliable, verifiable, publicly disclosed, and available on a timely basis. Finally, we will consider whether any contract design specifications, trading restrictions, and other protections should be in place to minimize the potential for price distortion and manipulation. Under Core Principle 5, all exchanges are required to reduce the potential threat of manipulation or congestion, particularly during spot months, by adopting position limits or position accountability. Staff will review each exchange's position limit and accountability rules to ensure that the limits are appropriate to reduce the incentive for a trader to attempt to distort the cash settlement price to profit on a large futures position. We will also review the procedures adopted by the exchanges for granting exemptions from these limits. I'd like to note that the core principle requirements for DCM contracts were added to the Commodity Exchange Act in 2000 by the Commodity Futures Modernization Act, or CFMA. At that time, the CFMA also repealed the section of the Act which embodied a public interest requirement that in turn included the economic purpose test. Under the economic purpose test, exchanges could only list for trading contracts that could be used on more than an occasional basis for hedging or price basing. As a result of the changes of the CFMA, staff has not routinely considered the economic purpose served by proposed contracts in its reviews. However, in view of the comments expressed by interested parties and several commissioners related to the potential hedging uses of these contracts, staff will consider the potential hedging utility of the contracts in its review. The comments of the panelists here today would be of much interest to staff in our analysis. Finally, in conclusion, with respect to the contracts submitted for approval, staff review is ongoing. Our review will fully consider the relevant statutory and regulatory requirements as well as the comments submitted. In particular, we look forward to the views provided today at this hearing, which should help inform staff about this issue so that the ultimate decision is based on a full consideration of all applicable statutory criteria and other relevant considerations. Thank you.
Thank you, Mr. Schultz. We're going to try to keep ourselves to a timeline to ask you quick questions and then get to our other panels, but I'm sure each of my fellow commissioners have some questions on what you see and what the law is. I understand from your testimony that you highlighted three considerations: the manipulation, Core Principle 3, that they have position limits, Core Principle 5, if I recall. And then you mentioned, it's not a core principle, but then you mentioned this issue of economic purpose, or whether the contracts are available or used for hedging. So my question's really around the third point. I'm sure we'll have a lot of debate on the other panels whether REN-track numbers work and whether these things can be manipulated and so forth. But it's the third point, maybe for Mr. Berkovitz as well. How do the five of us conduct our business? Is there an economic purpose test that's in here? If it was repealed in 2000, is it a little bit there because of, I can't recall, Section 3? How does that influence our decision making? Either one of you.
Now, Mr. Chairman, you've noted the other section that comes into play here, and as Rick described in his testimony, the public interest test was repealed in the Commodity Futures Modernization Act, so there's no longer an explicit requirement of an explicit finding that this not be contrary to the public interest as there was, which set up an actual test and a process for review. However, the law still requires that the Commission either approve or disapprove the contract, and if the Commission finds that would violate the Act, then it can disapprove the contract. So in the would violate the Act is implicit rather than explicit, as it used to be, that the Commission is not finding that the contract was somehow contrary to the findings and purposes and the whole purpose for which the futures contracts are trading. So within that, Section 3, the findings and purposes, is an implicit authority for the Commission to make a determination of whether the contract would accomplish something consistent with the purpose of the Act, such as managing and assuming price risks.
But is it that it violates the Act, or is it just that, I mean, is this one of those, 50-50, if 51% sort of you think it's this way, then, or is it got to, as you say, violate the Act?
Well, I think that's up for the commission's judgment as to whether indeed what the degree of how the commission concludes in terms of whether it would violate the Act. I think that's one of the judgments that's reserved for the commission.
Well, I'm sure others will ask you further questions on it. Can I ask you a couple more questions that actually, because they're kicked up by the later testimony by the Motion Pictures Association of America, so I thought I may as well just ask you as our general counsel. But they have in their testimony that the commission should disapprove. They're recommending, I think everybody knows this, that this be disapproved. But they think that it's, quote, outside the commission's jurisdiction. Do you think these contracts are outside? I mean, there may be other reasons. They have 5 or 6 other reasons to disapprove it. But do you think these things are outside the commission's jurisdiction?
There's the threshold jurisdictional question of whether these are contracts for future delivery, and I think if the commission concludes, and based upon the staff's recommendations, that they are indeed contracts for future delivery, then they would be within the commission's jurisdiction. Now, the testimony of the participants today and the written testimony indicates why, in their view, they're not contracts for future delivery, and the staff analysis, as Mr. Schultz can explain, is examining those issues as to whether that goes to the jurisdictional question of whether they're futures contracts or whether these futures contracts are susceptible to manipulation or meet the criteria. So there's...
No, I understand. And on the manipulation and other things, I'm not asking that right now. I'm just trying to understand. They say it's outside our jurisdiction because it's not associated with a financial, commercial, and economic consequence. I tend to think it probably is, so I'm not asking that. So that's just one commissioner's view. But then they say it's beyond the control of the parties to the relevant contract or agreement. This is out of our statute, they're quoting.
I believe, and Mr. Schultz can also answer on this, I believe as a preliminary threshold matter, the staff's conclusion is that these indeed are contracts for future delivery, and therefore they would be within the commission's jurisdiction.
Let me just see. I think my time might be up, so I was just seeing if there was any other question. I'm going to turn to Commissioner Dunn.
Thank you, Mr. Chairman. Let me take up where you left off with Mr. Berkowitz. You thought you were going to be the potted palm here, didn't you? Not quite so easy. Mr. Chairman, Mr. Berkowitz, in his capacity as our general counsel, testified in front of the House Agricultural Committee, and I would like to insert that testimony as part of this record because I thought it was an excellent procedural piece.
So done.
Thank you, Mr. Chairman. Without getting into how the bureaucracy works, but would you enlighten maybe the commission, but the public on when these types of applications come through, what is the role of the Office of General Counsel in these requests?
The Office of General Counsel has two basic functions. One is to function as the commission's legal advisor to provide legal advice on questions of law to the commission. Also, the Office of General Counsel works very closely with the divisions, with the Division of Market Oversight, with Mr. Schultz and his staff, and in analyzing the legal questions that come up during the Division of Market Oversight's review, as well as reviewing the staff's work for legal sufficiency, hopefully with the goal of, so when the Division of Market Oversight would provide a recommendation to the Commission that any legal issues would have been resolved, and the staff can present a recommendation to the Commission, and any legal issues would have been either resolved or presented clearly for the Commission to determine.
So if the recommendation coming from the Division of Market Oversight to the commission would have the assurance of the Office of General Counsel that is in compliance with the statute.
That would be the goal of both our offices, yes.
That's correct.
Well, Mr. Sheets, so just so you don't feel left out, some of the things that we're looking for under the new exchanges on those, they are what is called a self-regulatory organization, an SRO. But I believe in your testimony you point out that they do contract out with with an entity for some of that regulatory oversight. Could you amplify on that a bit?
Yes, the primary responsibility for oversight of all contracts is by the exchange, and some of this responsibility be contracted out to the National Futures Association. Ultimately, the exchange has final responsibility for making sure that it carries out all of its self-regulatory functions, and of course the Commission also, through its oversight, its surveillance and compliance functions, would be also looking at the exchanges to make sure that they carry out their responsibilities.
And how do you assure yourselves, the division, that those core principles that you talked about are in fact being met?
As I mentioned, with respect to contract approvals, and as well as looking at contracts that have been filed under certification provisions, the primary focus is really susceptibility to manipulation. And again, there's a core principle 5 on spec limits, but it's essentially to serve that same purpose, that there's limits in place that would minimize the susceptibility to manipulation. So in looking at a particular contract, and again, if it's a physically delivered, obviously there's different procedures and things that we'd be looking at. But when you're talking about a cash-settled contract, fundamentally we're looking at the nature and the process for deriving the cash settlement price series. And if it's, in this case, an independent third party, it's not something that's been developed by the exchange. Some cash-settled contracts are. This would not be. We would look to the nature of as to how that particular price series is developed, the reputation, the history of the entity that's actually compiling the number. I mean, for example, you look at like something, whether like for Eurodollars, if the British Bankers Association prepares that, it's a long history. In this case, we're looking at Rentrack. What procedures do they have in place? What mechanisms are there to ensure that the price that they come up with is meaningful, representative, reflects actual box office receipt numbers? We'd also be considering any other mechanisms or procedures that the exchange may have adopted that might go to trying to minimize the susceptibility to manipulation, prohibitions on entities like at the studio or Rentrack that they would not be allowed to trade the contract. So the essential focus is on the nature of that price series. And something else I think that's important to note is that in general, when exchanges pick a cash price series for a contract, in some cases it's something new that's designed for the contract, but in most cases they're using a price series that's already in existence, and that's the case here where the Rentrack numbers have been out there, and the ultimate numbers that they combine with the small amount of information gathered from the studios, and that's published and used for other purposes, in settling various contracts in the film industry, and that it's generally widely viewed as being, at least our initial examination, as being representative of actual box office receipt numbers. So it's a number of factors that we would be considering, but all going to the ultimate reliability, acceptability of the number.
Well, I'm curious then, how would the Commission investigate and prosecute possible movie futures manipulations attempts?
I think that the process, and our Director of Enforcement may want to comment, would be probably similar in the sense that if there's some evidence that a particular number that's been released seems to be inappropriate through our surveillance function or through information we receive in the industry, combined with our large trader data, because again these are fully regulated markets. We will have, on a daily basis, information about all large traders. So if there's some information that would come in that would suggest something inappropriate, we could quickly look to see if that matched up with the positions of traders in the market, and then conduct further examination, talk to the parties involved, the exchanges, RenTrack. That information, the RenTrack data, is all available to the exchanges to assess the completeness and the accuracy of the numbers. It's auditable. So
we can, in fact, take a look at the numbers that were presented, and we determine whether or not those are correct numbers in RenTrack, and I guess in Variety as well.
No, I don't think that's necessarily what we can do. I mean, the ultimate objective here in looking at a third-party index is that are there procedures and mechanisms in place such that we have confidence that the number that's used is reliable and representative of what it's trying to measure, in that case, box office receipt numbers. We would not contemplate and would have the capability to actually go and survey every theater or every reporting theater throughout the country to actually tabulate that and make sure that that number is correct. But that's why it's important to look at the reputation, the history, the nature of the price series, in this case the RenTrack data, to get comfort that this third-party price series is representative. It has the proper procedures and protections in place to ensure that it is a representative, meaningful number. The people in the industry do look to it as being reliable.
I'm curious, how much resources are you going to devote from the division to oversee this and do rule enforcement reviews, et cetera? Are you going to do this on each contract?
Fortunately for most, well, maybe unfortunately has been mentioned, many new contracts don't succeed, so we'll have to see what happens. But fortunately for those that do, they tend to generate volume and open interest at a somewhat slow pace, so it gives us an opportunity to start devoting resources to looking at the particular contracts, having a surveillance economist, for example, become familiar with the industry, the reporting, looking at the large traders. Ultimately, as far as the commitment of staff resources, it's hard to say now because we don't know ultimately whether these will succeed and how large the markets will be. I mean, if they don't achieve, if they trade at some fairly small level, there may never not be any traders of any size that would really ever pose any significant concern. If they do become quite widely used, then obviously we'd have to devote more resources to that. I know that the chairman has worked tirelessly to try to work to get us additional staff, which we would tend to devote to not just to these markets, but to any new contract.
Sucking up won't get you any more resources.
Can't hurt.
Mr. Chairman, I think my time's expired.
All right. Thank you, Commissioner Dodd. He's probably right about the last comment, but we thank you. Commissioner Summers.
I'm going to follow up with regard to some of the questions that we have regarding Core Principle 3 and the contracts being susceptible to manipulation, and ask you if you could talk about other contracts that are traded on other DCMs that we have experience with that are based on industry estimates, that are based on numbers from these third-party vendors, and what our experience is with surveilling markets that have these kind of data sources.
Yes, I think there's probably a number of contracts that have been either approved or traded or currently trading where settlement is based on some sort of a third party a number. For example, Eurodollars is settled to a third party index. The feeder cattle contract is settled to an index created by USDA. The CME has developed a number of real estate index contracts, which and also some insurance contracts, which I think is to some extent are similar to the ones that are talked about here, because you're talking about contracts that are based on transaction prices for various real estate in different cities. It's a number that's developed by S&P again, not for futures trading, but separate. You know, the CME developed a futures contract to use that number. But again, it's in a sense, when we looked at that, it was a matter of looking at S&P, the procedures in place to kind of be comfortable that, well, this price series they use to evaluate real estate in various cities is meaningful, representative. Again, not that we would have the capability to go out and do some sort of an audit of all the, you know, the transactions, but again, it looks to the nature of the entity that you know, S&P is in the business of doing this, that you know, their reputation and also the specific types of mechanisms and procedures they have to actually go out and develop the index. So in a sense, this is somewhat parallel to that, in that we kind of looking at, well, who is Rentrack and what is their reputation, their history and all in the industry, and the nature of the price, in the sense that this isn't something that was developed for these contracts. It pre-existed. They chose to use this, as exchanges can explain in more detail, but they chose to use this price because of their view that it is representative, meaningful, and you know, the industry generally views it as an acceptable number that's not prone to distortion.
And with these other contracts, how are the contract terms and conditions stipulated for the final settlement? Are they based on an estimate? They're based on whatever this real estate estimate number is, regardless of whether or not anyone is validating that number?
Yes, excuse me, it's based on the actual number that this third party would put out. You know, whether, you know, if it's the real estate index, the number the S&P would put out. If it's the, you know, Eurodollars, it's the number the British Bankers Association puts out. If it's you know, like I mentioned, like feeder cattle, it's the number that the USDA puts out. Again, because the focus, I mean, is how the settlement price is actually determined, and the reputation, the reliability of that number, so that because we can't go back for each month and do some sort of analysis to say, you know, in all these contracts and say, well, we've duplicated the effort, and yes, we think it's accurate. It really has to go to, we think that the provider of the price has, you know, is reputable and has procedures and mechanisms in place to ensure that it is a meaningful price.
And with these other contracts, what are the exchange's obligations to verify that these prices are right, and have the exchanges had any problems in the past with validating these numbers and making sure that these numbers are actually reliable?
In a sense, the exchange's obligations are similar to ours, because when they're designing a new futures contract, I mean, you may be looking whether you do cash settlement or physical delivery, and for many of these, physical delivery is not possible. So if you're doing cash settlement, you have two options. You can either develop your own price series, or you can look to something that's generally considered to be reliable that's already pre-existing. So in that sense, by choosing a particular index, they are making kind of the same type of calculation that I'm saying. They're not they are not, and they don't have essentially the capability to go out and actually verify that, you know, that all the numbers that go into calculating the index are bona fide. It's in a sense you're relying on the third party to do that. So it's kind of the same type of approach.
My other line of questioning is under the core principle 5 with regard to the either position limits or accountability levels that the exchanges may impose, and how we decide whether those are appropriate based on a new contract that we don't know a lot about the traders' incentives to, we're not familiar with the industry yet. How do we know that those levels are appropriate at this point?
For cash settled contracts, unlike physically delivered, where you kind of base the spec limit on deliverable supplies, at least for the spot month, for cash settled contracts, the real focus is on what you had mentioned, trying to set numbers that would tend to minimize the potential for a trader to want to distort the underlying price to the extent they have that ability. And I think here, with some of the unique characteristics of these contracts, the fact that it's based on a single movie, the kind of the narrowness, we would want to focus on a number that is, appropriately tailored to the nature of the particular contracts. I can't tell you there's a specific formula or some rule of thumb, not just for this, but for any cash-settled contract. But it's something that we're looking at in the sense of trying to assess what numbers, what levels would make sense to minimize that potential, and then and presumably we would try to set those at something that's relatively low, at least at the start. And then exchanges, of course, can grant hedge exemptions, but also be looking carefully at the nature of those and how they would relate to whether that particular trader's interest in the industry, so that it doesn't create some sort of untoward incentives towards distortion of the prices.
Thank you, Commissioner Summers. Commissioner Chilton.
Thank you. I want to follow up a little bit on the first part of Commissioner Summers' questions. I had concerns, as people have talked with me about these issues initially, about the run track numbers, and I became less concerned from the standpoint that they're generally accepted. I still had some questions about them, and still do, but had less concern now than I did. But I liked the sort of poignant questions you were asking, and it made me think that, nobody regulates Rentrack, and so they can tell us, well, we look at this many theaters and we select them, but nobody looks at them you remember, Reagan said trust but verify. So the only time we really come to look at Rentrack's numbers, it seems, is if there was an enforcement problem. I mean, if we thought there was a problem, and what I like to say is we should be more like, the police department sort of looking at everything instead of the fire department coming in to, hose down the charred remains of damage. So I guess I am a little bit concerned. We have this issue, and I know this gets me into trouble a little bit, but with Platts, where there's a number that's out there for energy prices, and it's generally accepted, but we don't know how it's come up with, and when we ask them, they won't tell us. This seems like this could fall into this same sort of bailiwick, and I just raise it as a point. I don't know, Mr. Schultz, if you had any comment on it, but Commissioner Summers got me thinking about that.
Well, first, I don't want to make it sound like we've definitely formed conclusions yet. That's the whole Rentrack number in the process is something we are looking at. But again, the points you raised are things that we definitely are considering. We do want to know exactly how this number is generated, the mechanisms. As I said, we have a lot of initial information that most of this is automated, coming directly from the theaters. There's protections in place, presumably, that would prevent, generating numbers that are false. But again, those are the types of things that we do want to look at to make sure that it isn't just some sort of an estimate that someone can easily.
All right. I mean, we're not surveilling the Rentrack system.
That's
so
correct.
The only time, if we suspected a problem,
if we suspect, I guess with any contract, if we saw evidence that the cash price series no longer seemed to meet the requirements, that we would look at, that it's not reliable or accepted or there's been manipulated, we would go back to the exchange and tell them that they need to either not trade the contract or to look for another cash price series.
Yeah, or
for any contract.
Or we go to our enforcement people and
yes.
get a subpoena and we.
But yeah, to deal with some event or problem that occurred. But I'm saying going forward, we wouldn't just let it stand.
Okay. We're using the light. Am I over my time? We're not using it anymore. Okay. We're going to try to.
We'll try to do it on the next round.
Try to oblige the chairman, but no lighting assistance. Mr. Berkovitz, I want to go back to, I said in my statement was I want to look at, what's a commodity, is there manipulation, and is it a legitimate hedging vehicle? So those are three things. So to follow up on the chairman's question, and excuse me for just looking at the Act itself, but Mr. Berkovitz, you said, as to our jurisdiction, the Act says that we have jurisdiction over contracts for the sale of commodities for future delivery. And, I think, well, I'm willing to, for the sake of this question, say, okay, they're futures, but is it actually a commodity? I mean, is there an underlying commodity here? Or what would that be?
The commodity would be the service rights and interest in which the contracts for future delivery are dealt in, which would be the box office receipts as defined in the contract that is subject to approval. It's these box office receipts.
I think it's the box office receipt number. I mean, I guess in a sense it would be similar to the S&P real estate price index number or the consumer price index number that's used to settle some futures contracts.
So when we look at 1A13.4, it says an occurrence event or occurrence or contingency. The occurrence would be the box office receipts. Correct, Mr. Berkovitz?
You might want to
Three
push
little,
your mic.
yeah. Okay. Yes. Okay. So the occurrence would be the box office receipts, and it said that it has to be then there, big I below that, Mr. Berkovitz, says beyond the control of the parties to the relevant contract, agreement or transaction. So, and you could, I guess it's debatable, but I mean, movie studios are all about producing movies. They're all, their goal is, if they had a mission statement, my guess is it's, box office returns. So that's really their focus, is box office returns. So it would seem to me that they would be able to control, to some extent, the occurrence. And therefore, I wonder whether or not these would be just susceptible to manipulation by the studio, just on its face, hypothetically, because they are a party to the contract, and the contract is based upon the occurrence.
That's a good question, and something that we had looked at in connection with the reviews of the exchanges and is ongoing with respect to this. And I think there's maybe two ways of looking at it. One is kind of the focus on the susceptibility and manipulation of the cash settlement price series, which I talked about, and whether that the numbers that are generated actually reflect the number of people that went to the movies and what they paid for it. And looking at, does anybody really, whether it's a studio or whatever, have any way to control that number, to influence it, or is it just an automated procedure that just feeds data? I think probably more what you're focusing on maybe is trading prior to that, where a studio can maybe through its marketing budget or whatever influence what the ultimate the number of people that actually go see the movie. And that's something we want to look into too. And I guess we've heard different things. And on the one hand, I mean, some have said that, well, that as much as they would like, studios generally don't have this much of control. Otherwise, there would be no flops. I mean, so that it's, I don't know. This is something we're looking at. I don't know what the answer is, but to some extent, it's, how much control do they really have? And I guess also to look at it in the sense of, is that, if they do adjust their budgets or whatever, or put out press releases or whatever, is that in the sense of manipulation, or is it really more just influence and is something part of their normal business operations? But I understand your comments.
But I mean, they have some impact on the price. I mean, they can pull the movie. They can do the things you're talking about. They can have Russell Crowe go on Jimmy Kimmel. I mean, they could do things that have an impact really up to the very last minute. So, I mean, I see, again, I guess it's debatable, but I see no way that they're not impacting the price, that they are not a party that has, that is not, that it cannot be beyond the control of the party, and they're a party to the occurrence. Now, Mr. Schultz, you at one point I think you said, but you know, these are really based upon what consumers do, that they and maybe not by the studios, but what consumers do at the box office. Is that correct?
Yes, I think that's why people, I mean, not for these futures contracts, but in general, why other parties have various contractual obligations that kind of go to these box office receipt numbers.
So they sort of look at the value generated in cash by the actual ticket window sales.
Right, yeah, and that they're viewed, as we understand, at least preliminarily, that they're viewed as a reliable indicator of what actually occurred, how many people went to see the movie and the price. So this finishes my line, Mr. Chairman. So there's another part in the act there, Mr. Berkovitz, that if you didn't accept my original, it's going to be too little I, 13. But if you didn't accept my contention that the studios are a party that can have a influence, that has control over the price of the occurrence, and therefore they can't be involved in it. If you didn't accept that whole argument, then you have this other one, that too little I, that there's another possibility for determining that there's an underlying commodity here, and that's a commercial rate of return. But that would require, as you see down there in too big I, that it would require, it says, based solely on one or more commodities that have no cash market, right? So, but Mr. Schultz just said that there is a cash market. I mean, that's the people buying the box. That's how we're making these determinations. So what section of 1A13 could we rely on to determine that this actually is a commodity? And that's my last question. I'll be quiet for that for a little bit, Mr. Chairman. Thanks for your indulgence. Could I just make one comment before he answers? I think my view, at least, would be that there really isn't an underlying cash market here when you're just looking at a number. That I think what we historically viewed as a cash market, where there's an actual physical commodity that people are buying and selling something, whether it be treasury bills or corn or crude oil, and that where whether it's prices of real estate or the consumer price index or domestic box office receipt numbers, that there really isn't a cash market per se where people are buying and selling some specific commodity.
What are box office? I mean, people are paying cash to buy a ticket to a movie. They're aggregating that and reporting it. What sort of market is that?
It's a revenue number.
A revenue number. Okay. Berkovitz, you want to comment?
I think the question of the cash market would relate to the cash market for the number that is the box office receipts index, not whether there's a cash market for tickets. But it would be the index that's produced by Rentrack and released by the studios. Nobody's buying or selling that index, like the S&P 500 index. You don't own that. The other question I would say is that whether something is an excluded commodity or not, we're looking here as whether this fits in the definition of an excluded commodity, which would help aid. Okay, we would analyze and say if it's under this 13 little I, 2 or 3 or 4, and it fits in, it's an excluded commodity, therefore it is a commodity. But if it's not an excluded commodity, that just means it's not an excluded commodity. It doesn't mean it's not a commodity. So you could still have a commodity even though it's not an excluded commodity.
I mean, it's got to fit into the law. How is it? It's got to be a commodity. It's got to be a commodity, right? I mean, 1A13, it's got to be a commodity. So which commodity is it?
Well, there are several types of commodities. There are excluded commodities.
The ags excluded and the exempt.
Commodities.
Okay, so which one is it?
Well, if it's not an excluded commodity, it would be an exempt commodity. Commodity is not an excluded commodity or an agricultural commodity.
Sort of like metals?
That's right. Metals is another.
Okay, I'll chew on that for a while. Thank you.
I'm going to turn to Commissioner Malia, but that was very helpful, that back and forth maybe, or at least for this, Commissioner. So, thank you.
I agree that that was helpful, and I'd like to kind of go along down the line of questioning a little bit and maybe ask some more comparisons to specific contracts that have been traded. I assume this is not the first contract that has generated some opposition or concerns from within the industry, or at least one aspect of the industry. How does this compare to other specific contracts you've looked at in your tenure here at the Commission? And one contract that was raised was a Head Street contract regarding which traded, and I don't think it trades anymore, but the corporate earnings future. That seems to be similar, kind of an opinion of corporate earnings and in the information controlled specifically by a corporate entity, Coca-Cola or General Electric. They seem to have all the information about what the future will be about that product. Can you kind of answer that two-part question?
Yeah, I guess on the first one, I think in the introduction of futures contracts in most new commodity areas, at least from my experience, has generated a lot of opposition. I think ultimately many members of the industry ultimately come to use them. I mean, even going back, I think, to originally the stock index contracts were opposed strongly by the SEC, but of course now they're widely integrated into risk management. Same thing, I think, with some of the Treasury futures and energy futures. So I think, so I think that, to answer your question, I think that generally that it's, there's tends to be a view that people don't really understand how the contracts can be used for risk management, and they, there's an opposition to that. And in many cases, the contracts never succeeded, as I had mentioned. But those that do, the industry generally comes on board and trades them, and that's actually probably why they succeed. With respect to some other contracts, like I mentioned, and whether it's corporate earnings or something like that, or another index of whatever, whether it's a macroeconomic index or, like I said, or the insurance. We had contract based on insurance, real estate, and other things. I think that there is some analogy to that, and it may not be exactly the same, but in this sense, in terms of the computation of the cash settlement price, but to the extent that it's narrow, that it's earnings of a particular entity, that's probably a similarity to this, where it's focused on a particular movie. It's not some sort of a aggregate of a number of movies, and you have an index. It's looking at the actual revenues of one. So I think there is some parallel there potentially.
Do you have any concern about the narrow nature of either the corporate futures or this product in particular?
Yeah, we didn't on the other. This one we did from the beginning, and that's why we had in working with the exchanges had got their consent and this provision that they would be submitting these contracts for prior approval, because in that sense it was unprecedented. The other contracts were self-certified, so the Commission never really had to take action, and then, as you said, they never really traded anyway. But in this case, it was something. I think that's probably one of the key novel features of these products, and why we wanted to look at them more closely.
Obviously, we all know that Congress has taken, or some in Congress have taken a position that legislation's out there, but I just want to make sure that you and your staff don't have any questions that you have not had answered, or the contracts have not, the companies have not provided data to you that you're seeking. Do you have every bit of data you ever wanted on these contracts?
Yes, they've been very responsive to information that we've requested, and as part of the review process, it's working with the exchange and gathering more information, and we may be going back requesting changes to terms, whether it be speculative limits or other features of the contract. But they've, to date, have been very responsive. We had no issues.
Do you have any specific questions regarding the oversight of possible enforcement of these contracts if they're approved?
Not at this time. I mean, that's something that we're looking at, and it's part of the overall process. And in evaluating the settlement, the price series, and all of the mechanisms that the exchanges have in place for oversight.
Do you have any doubt that if approved, your staff could identify and enforce against any possible manipulation of these contracts?
I can tell you that our staff would be very much focused on, if they trade, on oversight, evaluating the large trader data, the trade data, monitoring, information in the market to ensure that there aren't violations.
Okay,
Whether we can, be perfect, catch everything, I can't claim that, but we would be vigilant.
Good, thank you.
Thank you, Commissioner Malia. I don't know that there's any more rounds, but General Counsel Berkovitz may have an answer about commodities, excluded commodities, exempt commodities. That would be helpful, by the way.
I'd be happy to expound on that. I wanted to to supplement a previous answer I had given to a question that you had about the...
one of my questions.
One of your questions, Mr. Chairman.
All right.
So you had asked about the standard for the commission would violate the Act, and what standard the commission has to determine that something would violate the Act. And the commission's regulations in Section 40.3D says that the commission may find that it is unable to approve a product of instrument. The commission is to briefly specify the nature of the issues raised, and including the form or including a finding that the product would violate, appears to violate, or the violation of which cannot be ascertained from the submission. So those are the standards within the commission's regulations for finding under the statute that disapprove.
And if my fellow commissioners will give me this benefit, because I didn't plan to ask a question, but the earlier question I had to do with the economic purpose. Are these contracts used by some hedgers out there? The 2000 law repealed all of that in specific, but some of the opponents of this, contract have said, but there's still this Title III. Title III for the public is just our sort of purposes part. Every law seems to have a little section about findings and purpose, and that's what Title III is, as I understand it. So my earlier question is does that get read into this decision? How much weight does it have in this decision? I mean, it seems everybody agrees that we have to focus on core principle 3, which is manipulation, core principle 5, so forth. But this, economic purpose, is it used for hedging, is one that I'm most interested in. Is that on the table, not on the table? How much is it on the table?
It is not as prior to 2000 as an explicit step that the commission is required to take in arriving at its judgment. If the commission were to conclude that because this has no economic purpose, or because it can't be used for managing or assuming price risks, because it's fundamentally inconsistent or appears to be fundamentally inconsistent, or you can't ascertain whether it's fundamentally inconsistent with a finding and purpose of the Act as in Section 3, I believe the Commission would have the authority to disapprove it.
And so so it's a matter of interpretation, but if we were to do that, is it that no parties would hedge with it, that just certain key movie studios wouldn't hedge with it? Because there's testimony that we're about to hear from another panel that lists, 6 or 8 or 10 areas of people that might hedge with it, and there's other testimony that says, some parties, like the major movie studios, wouldn't use it for, well-articulated reasons in that testimony. So since we don't normally read in any economic purpose test, in fact, have we ever done that in the last 10 years since the Commodity Futures Modernization Act? So this would be a first for us. It would be good just to get a guidance. Is it there's 0 hedgers, lots of hedgers? What would be the thing?
I guess what I could comment on is what staff looked at, when we had the explicit economic purpose
in
test.
the past.
Said, yeah, and it was that, that the contracts could be used for hedging on more than an occasional basis. I think that came out of in '74 when the CFTC was established.
So I'm sorry, could be used
for
on
hedging.
more than an occasional basis.
More than
All right, that
occasional.
answers my question.
Yeah. So it wasn't the entire industry. We would just, if there were some segments of the industry or individuals that could use it, and reasonably expect them to. Obviously, they don't swear to that. But
I thank my fellow commissioners for indulging me as Dan, brought that back up. So, here, all right.
I'm sorry, I had a little time to digest Mr. Berkowitz's stuff, and I think I know where you were, but on the 1A13, I mean, you'd mentioned exempt contracts, but that one is really defined by a negative. If you're using that for the definition of a commodity, that says it's not an ag and it's not an excluded. So energy or metals are in that. But I think what you were talking about, this goes back to what the chairman was asking originally. Again, is it a commodity? Is right at the beginning of the act, and that's for a commodity, which includes all. It says, and all services, rights, and interests in which contracts for future delivery are presently or in the future dealt with. But that's sort of circular in my mind. I mean, you can't just say it's a commodity because we're going to have a contract on it in the future, therefore it exists. It's sort of like, the commission, long before any of us were here, considered terrorism contracts. I mean, there wasn't an underlying, it was when will the next, terrorism act happen. So is that really what we're looking at as for why this would be a commodity? And what would be the difference between a terrorism contract and a box office contract? And that's all I have. Thank you.
The definition that was put in the 1974 Act was intended to be extremely broad. As you're aware, prior to 1974, every time there was intended, a commodity would come under regulation. Congress actually had to pass an act and say, enumerate the commodities within the act. So in 1974, the congressional decision was, we're going to cover everything that now is potentially for future delivery or something in the future maybe. And because of the concern that you just raised, Commissioner, because there might be a terrorism contract, and because concern that there wasn't really anything to limit this, is why they put the public interest test in 1974, so that this would be something that could legitimately be used for hedging. And the public interest test was interpreted by one of my predecessors, who I believe is in attendance today, in legal advice to the Commission some 25 years ago, to mean an economic purpose test is how the Commission generally implemented it. And it was, I think, for the policy considerations that you've identified, that there was the public interest test. In 2000, they took out the public interest test, but for the reasons we've just been discussing, we believe that within the findings and purposes, together with the requirement that the Commission find that it not be violative of the Act, that there still is authority within the statute for the Commission in a circumstance where the Commission would believe that the contract would violate the finding and the purpose of the Act to reject that contract. So there is residual authority, we believe, to take care of that concern.
I want to thank Mr. Schultz, Mr. Berkowitz, and welcome our next panel up. I have no doubt that over the next couple of weeks, as we're continuing to deliberate, we'll have a lot more questions of you about the Act, about these contracts, and so forth. do this without a quorum? Can I at least introduce them? Hey, Eric, can I do this without a quorum? Can I introduce them? Okay. I want to thank our second panel, our first outside panel, for being here today and their patience with us as we're sorting through these issues. This, again, we're not taking any votes today, but this is a public meeting so that we can really inform the Commission and the public on these important matters. I want to, I'll just go, I guess, left to right, and the next panel I'll go right to left, I guess. But thank, do I have the same list here? Hopefully. Well, it's in a different order. All right, but Richard Jacobs from Cantor Futures Exchange. You know, I keep thinking about an old name that you had, but president of Cantor Futures Exchange, who is one of the applicants. Robert Pisano, who is from the Motion Pictures Association of America, and I guess I think of you heading it up, but still as the interim chief executive officer of the MPAA. Alice Newhouser, who's a principal of Complete Rights Management, and then Clark Halrin, who's a managing director of Clear Scope Partners. We thank all of you for being here. Your written submissions will be put up on our website. I know some of them came in this morning, but we'll put them all up on the websites for the public to see. If you could possibly keep and help us out with summarizing in 5 minutes in an oral. And I know that's hard because I do it a lot in front of Congress. And then there's also going to be some lights that our good friend Doug is going to try to do and we'll try to police ourselves too when we do our Q&As. So, Richard, do you want to start?
Sure, thank you, Mr. Chairman. To begin, I'd like to acknowledge the hard work of the Commission staff through the multi-year process during which our exchange was approved. In that multi-year process, we filed over 300 documents, many of which are specific to the domestic box office receipt contracts that we're proposing. We call those DBOR. The staff has been thorough and forthright with regard to the requirements of approval. In late March, Cantor Exchange submitted its domestic box office receipt contract to the Commission for approval. Although we had expected to self-certify these contracts, we entered the formal process when the Motion Picture Association of America raised objections. We appreciate this opportunity to publicly clarify the benefits of our DBOR contract. The 6 major studios that make up the MPAA are all owned by large media companies and therefore have the ability to self-fund motion picture production and development and distribution. We accept that these industry giants may not find DBOR contracts an attractive hedging vehicle. However, others in the motion picture industry, some of whom are speaking here today, believe that hedging highly speculative film investments is indeed a sound idea. The fact that the MPAA members do not wish to participate does not invalidate the market. OPEC's participation was not a prerequisite for NYMEX crude oil futures contract, and neither should MPAA's participation be a prerequisite for DBOR contracts. Hedging tools like DBOR futures will foster competition among distributors, provide access to a wider array of film financing, and allow for more effective allocation of theatrical resources and entertainment dollars. After reviewing the many self-contradictory and baseless claims made by the MPAA regarding our contract, we conclude that their opposition is primarily intended to maintain the status quo of film financing and distribution. I'd like to briefly address 4 key aspects of our proposed market: the hedging utility of box office contract, the market's potential impact on the motion picture industry, the need for contract design features such as position limits, and concerns about inside information, manipulation, and the integrity of the final settlement calculation. Everyone here today, proponents and opponents to box office futures contracts, agrees that film investing is an extraordinarily risky business. The disagreement is whether a transparent public market is desirable or even necessary as a mechanism to manage that risk. Opponents contend that since they won't use a futures market, neither will any other commercial enterprise in the motion picture industry. They conclude from that box office contracts, therefore, are just a gambling device. Today's hearing demonstrates that a growing number of legitimate hedgers are coming forward and publicly stating their support for the contract. My written testimony provides several hedging examples using DBOR futures. These examples were derived from actual conversations with potential market users, including investors, theater owners, and others, and I'm happy to answer questions on these examples. Both proponents and opponents of box office contracts also agree that DBOR futures will bring new and significant level of transparency to box office reporting. Again, the disagreement is whether this transparency will benefit the industry or harm it. Currently, the major studios operate in a financial world where their prognostications about a film's economic potential go unchallenged. Investors in film have no means to quantify the impact of a studio's decisions. Neither can they protect themselves from the day-to-day decisions that are being made about their investment. This inhibits investment. Also, the MPAA's position fails to recognize the large number of institutional and private investors that would like to assume the risk of film investing, standing shoulder to shoulder with the MPAA members, provided that the risk can be transferred in a low-cost, public, liquid exchange. The MPAA's concerns that box office contracts would imperil their investment and bring harm to the reputations of the directors and talent in filmmaking is simply not supported by any facts. We do believe that position limits are necessary. Futures contracts are a risk transfer mechanism, and we agree with the MPAA that futures should not be used to create perverse economic structures or incentives. The motion picture professionals and investors who bear risk should be able to use the futures market to mitigate that risk, but futures should not provide any incentive for film owners and distributors to create bad movies. Similarly, speculators should be constrained in the positions that they can take so that they may provide a meaningful liquidity presence, but certainly not dominate the market. Finally, with regard to final settlement, insider trading, and manipulation potential, I refer the Commission to my written testimony. However, I would like to emphasize the following. Final settlement calculations based solely on Rentrac's electronically captured box office receipts do not vary materially from that reported by distributors. I cite the case of Iron Man 2 in my written testimony. I have other examples here. We've compared these values for over a year and found no material discrepancies in those calculations. Second, contrary to MPAA's public statements, knowledge of the artistic content of a film by its directors, actors, editors, and others is not material, non-public information, simply because seeing a film is not a reliable predictor of box office revenue. With regard to manipulation, distributors determine advertising budgets, screen counts, and release dates. Certainly, these decisions impact box office results. However, overt manipulation of these cash market type activities would be readily detected. Furthermore, the economics of DBOR contracts are such that any profit garnered from this activity would require the accumulation of a relatively large market position that would be regularly and routinely surveilled.
If you can try to summarize.
We'll do that. Overall, we believe the opponents are correct to point out that diligent market surveillance is needed, but we also think they have failed to recognize the role of the National Futures Association and our own ability to detect fraud. Again, just like to thank the staff's efforts in this regard and appreciate the time.
Thank you, Mr. Jacobs. Mr. Pisano.
Can everybody hear? Fine. Good morning, Mr. Chairman and fellow commissioners. Thank you very much for the opportunity to be here this morning. I want to make clear at the start that while I'm here as the representative of the Motion Picture Association of America, which consists of the 6 studios, I'm also here as a representative of an unprecedented coalition. This proposal has succeeded in uniting what are historically warring factions of our industry and brought everybody to the table, and that would include labor and management, because 2 of the major unions are represented here, distributors and exhibitors, because the National Association of Theater Owners are represented here, and the 6 major studios and independent film producers, who together account for probably 95% of all of the movies released in America. So it's just not the 6 of us who are objecting to this. It's the entire motion picture industry, from production, distribution, marketing, work in terms of the workers, and the exhibitors who exhibit our movies in theaters. I'm here not necessarily as that representative. I'm also here as someone who spent 25 years in this industry at 2 studios as a senior executive and as the head of the Screen Actors Guild. And in particular, that latter responsibility has impressed upon me the work, the amount of work, and the effort that goes into each of these movies by the performers who actually make the movies, as opposed to those of us who wear suits and go to a studio office or write the checks. So I'm not a financier. I'm not a commodities lawyer. I would not be able to engage in the kind of colloquy that the Commission did with its General Counsel. But I'm here as a person who has actually made movies from the standpoint of production, distribution, marketing, and financing. And I've used all kinds of old-fashioned ways of hedging the risk when we make movies. We've pre-sold rights. We've done split rights. We have done external financing. My colleague at the end of the table, Mr. Halloran, was our banker when I was at MGM, and he was at J.P. Morgan. And we borrowed money the old-fashioned way from J.P. Morgan, and we paid it back because we invested that money in film and television product. So I come here as someone who's done it in terms of the way the industry functions, and I would like to make clear that speaking for the coalition that I represent, we have never, ever thought about hedging our risk or selling a movie short, and we never will. Because the first time we do that, the first time we go short against one of our own movies, it'll be the last time that we ever work with those filmmakers. And once that becomes public and in the community, it will be the last time many filmmakers will work with us. Because when we make a monetary commitment to make a movie, we're backing the creative integrity and vision of the people who are involved in the movies. And I can accept there are circumstances when financial engineering, synthetic derivatives, etc., play a role, but they certainly don't play a role in the process of creating this uniquely American product. So we operate in a world of creativity. We operate in a world of a unique product, and that brings me to some specific questions about these proposals. I've heard the term commodity, and I understand the popular view of what a commodity is. The only analogy I can think of, and analogies are dangerous, is that this would be like taking a contract out on Farmer John's spotted cow, because every single movie is unique. And you can't commoditize them. If you do try to commoditize them, you will fail. So it's not a commodity in the way I conceive of what commodities can be. There's no price discovery because you can't buy or sell the movie. You can't buy or sell movie box office. No one can pay cash for them. It's simply a synthetic, artificial piece of information that is released by the studios. And I can say that I probably bear some responsibility for this being in the public domain as opposed to inside industry information, because my studio in the 1980s, Paramount, was the first to release at the end of a weekend how good our box office was and why we had become the #1 movie for the weekend. So there's no price determination. I think the hedging aspect has been covered. The manipulation, as a former general counsel, I can tell you that this is a nightmare to try to control the use of inside information, and another reason why the studios and the independent film producers would never use it. So what do we have here? We have a synthetic based on a number that is not real in the sense of anybody actually using it. I think we've got something close to, or indeed a gambling contract. It more properly should be regulated by the gambling contracts and the Federal Wire Acts, and not be given the cloak of authenticity by being traded as a future. Thank you.
Thank you very much, Mr. Persano, and for even summarizing. Ms. Newhouser.
Good morning. Thank you, Chairman Gensler and Commissioners, for inviting me to testify today. I've been involved in business entertainment for over 2 decades. During that time, I've usually had some involvement in film financing, from managing $200 million revolving credit facilities to multiple single-picture financings for some of the largest independently financed pictures, including Terminator 2 and Cliffhanger. I've managed film financing for pictures ranging in budget from $2 million to over $100 million, the vast majority of which were released through standard studio distribution arrangements, including approximately 14 pictures in the last 4 years. In the course of that time, I've worked with studios, banks, independent financiers, international distributors, completion bond companies, and other entities critical to the financing of production of motion pictures. In addition to film financing, I've looked for opportunities with businesses ancillary to or which support film production. The most successful of those ventures was the development of the Raleigh Manhattan Beach Studios in Manhattan Beach, California. This film and television production facility was built in 1998 and was the first full-service production facility in Los Angeles in over 50 years. The facility was built on 22.5 acres and includes 14 sound stages, 8 production buildings, a commissary, a 4-story office building, and a parking garage. Establishing a new business model, we took the real estate development mall model and adapted it to the entertainment industry. So instead of a Macy's taking a long-term lease as anchor tenant in a new large-scale mall, we signed 20th Century Fox Television to a 5-year term as anchor tenant for Fox's television producer David Kelly, where he shot his shows Ally McBeal, The Practice, and Boston Public. In the real estate world, a 5-year lease would not have been considered long. However, due to the economics of entertainment, this was a workable length of time for establishing the necessary debt service for obtaining our construction loan. Since that time, the studio facility has been continuously filled with a variety of network and cable television shows, as well as major studio film productions. The studio is currently home to Marvel Studios, which was the base for the filming of this year's hit Iron Man 2, and where Marvel intends to shoot film Thor, The First Avenger, Captain America, and The Avengers. Over the years, usually at the request of various lenders, including GECC and JP Morgan Chase, I've been retained by various distressed entertainment companies on a workout basis to either restructure or sell the assets of those companies. Generally, this involves determining how best to exploit the existing assets in the various distribution channels on a worldwide basis, or packaging the assets, marketing them for sale, and identifying potential buyers. As a result of my livelihood being inextricably linked to the ongoing business of film production, I've been interested in the opportunity that trading in box office futures might offer to the film community. There are significant similarities between building construction and film production. Both require a significant amount of upfront capital with a long lead time to completion. Financing can have some similarities as well, with pre-selling in the form of office space leases for construction and output deals with foreign distributors or paid television providers for film production. The industry has been pretty successful in developing ways of mitigating the risks inherent in production, from buying weather and cast insurance to obtaining a completion bond to guarantee completion and delivery of completed product. However, unlike the building construction model, where the completed product might take a little while to fully lease up, generally the building has the same utility 2 years after completion as it does on the day it is completed. This is not the case for film production. Generally, the theatrical performance of a picture will determine its final ultimate value. International box office, pay television license fees, DVD sales, and downstream television revenues are all impacted by the initial U.S. box office performance. With ever-increasingly substantial investments in production and distribution costs, the U.S. box office performance becomes ever more important. While the ability of box office futures contracts to hedge some of that performance risk doesn't change the final ultimate revenues of a given picture, it does provide the financiers, whether studios, lenders, P&A investors, etc., the opportunity to alter the actual financial outcome of their investments. Just as this has been a useful tool for grain producers who are subject to the whims of the marketplace, such as when yields are greater than expected, so it can provide risk mitigation for those investors in the value chain of film production and distribution. I would like to see the opportunity for this hedging tool to be made available to those parties who are interested. I thank you again for the opportunity to speak today.
Thank you, Ms. Newhouser. Mr. Halloran. You might want to push. Yeah.
Sorry. Mr. Chairman and Commissioners, thank you for the opportunity to speak with you today. I'm the managing partner of ClearScope Partners, an entertainment advisory practice that provides strategic and financial advice to those either operating or investing in the industry. Prior to forming ClearScope in August of 2009, I was the managing director of JP Morgan Securities, a division of JP Morgan Chase. During my 23-year career at JP Morgan and its predecessor companies, I focused exclusively on providing financial advice and capital to those who produce or distribute intellectual property, including primarily theatrical films. While I was with the firm, JP Morgan was known as the dominant player in the entertainment financing space. Due primarily to my role at JP Morgan, I believe I have seen or provided virtually every form of financing for intellectual property that has existed in the last quarter century. I estimate that I have played a key role in raising approximately $550 billion of financing and analyzed virtually every business plan that's been in existence or has been contemplated. I've seen multiple cycles of investors enter or leave the industry, including Texas oil money, Middle Eastern oil money, insurance-backed financing, German tax financing, investments from wealthy individuals, and the latest round of financing from hedge funds. I have conducted business at each of the major studios, including Mr. Pisano's former studio, and that has existed during this time, and have been fortunate to serve as lead financier for such name brand companies as MGM, United Artists, and Steven Spielberg's DreamWorks in its various incarnations. I believe that my perspective on the industry is well-grounded and very long-dated. My focus with the products that are being considered by you for approval is simply to increase the sources of capital that are available to the entertainment industry. I believe this can be accomplished by allowing investors to manage the volatility that is inherent in the performance of theatrical films. The volatility experienced by many recent investors has caused a substantial withdrawal of capital from the industry. This is resulting in a meaningful reduction in the number of films that are produced on an annual basis, and therefore, in my view, has led to reduced employment opportunities and a reduction of film content export opportunities for the U.S. in general. I think this is particularly important as our film product is one of the U.S.'s largest export items. My thoughts are echoed in a letter that I bring to you written by John Miller, Vice Chairman of J.P. Morgan and the Senior Manager of J.P. Morgan's Entertainment Industries Group. Mr. Miller, who is perhaps the best known and a highly respected film finance professional, also notes in his letter the objection by various entertainment industry insiders to the product being traded on the exchange and being available to industry outsiders. He states, and I quote, "In recent years, studios have welcomed many risk mitigation techniques, including allowing those interested in investing in the industry to invest on a blind basis by committing to invest in films that are within the absolute total control of the studio and are not identified or even exist at the time of the investor's investment commitment. This allows the studio a significant hedge in managing the investment in their film slates while maintaining complete control of the process." Mr. Miller continues by stating, "I believe that having a hedging product such as a box office future contract will provide two key benefits. First, it will allow investors who buy into blind basis transaction a method to manage their risk and thereby encourage continued and additional investment opportunities. Secondarily, and perhaps more importantly, it would also allow investors to improve their investment opportunity by investing in individual films that have concrete and tangible information by which they can make informed investment decisions at the time of the release of the film. I continue to believe that increased transparency is positive to creating greater investment opportunities in the film industry." End quote. I agree with Mr. Miller's view and think that the box office future product can have a significant positive application in today's environment. I thank you for the invitation to be here today and look forward to answering any questions that you might ask.
Thank you, Mr. Halloran. Thank you, the whole panel. My first question for Mr. Halloran and Ms. Newhouser, is it your, what do you believe in terms of the words that were used earlier by our Director of Market Oversight? Not the law, by the way. But would these contracts, if they were to trade, be used for hedging on more than an occasional basis? I'll go all the way down the panel, but I'll start with the right side, Mr. Halloran.
I believe they will. I have arranged a number of...
Short answer, please.
Sure. I believe they will because it's very volatile and they need a hedge.
Ms. Newhouser.
I also do, and frankly, in discussions with various studios, we had high-level studio executives who were coming up with their own ideas of how they would want to use this as a hedging opportunity.
On more than an occasional basis. Mm-hmm. Mr. Pisano?
No, and no studio executive that worked for me would be permitted to do it.
I guess Mr. Jacobs has a view.
With sufficient liquidity, yes. Liquidity is certainly a primary factor in that, but yes.
Okay. So then my question for Mr. Halloran, again, going down, and maybe, why do you think there's this different view that Mr. Pisano suggests? So, I mean, I don't want to try to pit the two against each other, but you know more about the movie industry and your pinky little bit, than I will ever know. So,
I happen to agree with Mr. Pisano that I don't think the studios will short their own films. I think that would be very difficult for them to do, even though their corporate parents might want them to. I believe that the hedging of films, or what I consider the shorting of films, to be used primarily by film financiers. And I can see opportunities for studios where they really believe in their films, for them to, in effect, double down and, in effect, go long on the overperformance of their films. I think that can also be done by equity investors who are invested in film production companies that may be part of the corporate environment and the corporate security, to be able to, in effect, go long as well on film performance.
So maybe there's not that far a difference between you about the studio executives, but you think the broader marketplace would, on more than an occasional basis, use contracts such as these for hedging. Ms. Newhouse?
Yeah, I believe that as well. I actually have been speaking recently with some P&A financiers out of Canada.
P&A?
Sorry, prints and advertising. So when you're going to have a theatrical release, they are the ones who cover the distribution expenses, which can run, you know, on a lower budgeted studio movie, maybe $15 to $20 million, can run up to $60 million on a worldwide basis.
Mr. Pisano, so now that we may be narrowing differences, do you share Mr. Howren's view that maybe the studio execs wouldn't, but this broader group of financiers might on more than an occasional basis?
No, and let me elaborate just briefly on that. The notion that someone who's put $150 million into a movie, either the studio's money or an outside financier's money, is going to go long against it of your own money, I find that to be, I'll use the word ludicrous. I just don't think that happens. And so therefore...
No, but his point on the earlier one is that financiers who are putting up money, who might be in these blind pools, you know, that they're talking about, or other financiers might use these contracts to hedge their 10 or 20 or $50 million that they've put in.
To go short, in other words.
Yeah, well, to protect them. They're not a studio executive. They're a
right.
financier, is what Mr. Howren was saying.
I think when I talked to you informally, Mr. Chairman, I said that the fact that there is a short position, even though there's going to be a corresponding long position, out there is going to become a self-fulfilling prophecy. And so we operate in rumor and gossip, unlike Washington. And so the notion that you're going to take the rumor and gossip that now exists, and we all freely admit it, and cloak it with a financial aura of respectability by money, by going short, which is going to get reported in the press, is going to become a self-fulfilling
No, I understand that. Since my yellow light is on, I think, if I can just to hone in a little bit more, because I, with all respect, think you carefully didn't answer my question, is that Mr. Howren is saying is that financiers who put up money, they're not studio executives, he believes would use these contracts on more than an occasional basis to hedge that money that they have in. That's a little different than whether it's rumor or gossip, which is probably true. Even there's rumor and gossip even in the oil markets. But I was curious about whether financiers would use this on more than an occasional basis.
I don't. It's a matter of judgment. I don't believe so.
Okay. Thank you. Commissioner Dunn.
Thank you, Mr. Chairman. I must confess I'm quite out of my league in the motion picture industry. If it didn't have John Wayne, Gene Autry, or Hoot Gibson in it, I probably didn't see it. But I have to disagree with my colleague here when he says it's cool, but it's not business. I have a son that's in the skateboard business. It's cool, but believe me, it's business. And this is all business. It's all about how you finance and how you get your product to the marketplace. I would like to know about how difficult it is for these independent producers to get that backing and get to the marketplace. And I'd ask each of the members to talk about that have some knowledge of it.
It's more difficult now than I believe it's ever been in the last 25 years of my banking career. There is a huge amount of risk in the business. You have a number of published reports about declining video values, DVD values specifically. You have challenges in the advertising market in making television sales with what has happened with reduced advertising budgets of people who are buying television content. those transactions and those contracts are often used for this pre-sale financing, and that market, Cannes has just finished the film festival, and the word coming back is it was not very robust because people aren't buying their product. You also have the capital markets in a very challenged position. When I was a banker, I syndicated transactions to consistently between 30 and 40 banks around the world. There are literally 9 of them now, and they're very conservative in their approach, the ones that are still hanging in there. And I think that you can invite more capital to come back into the business if you give them a way to control the volatility.
Yeah, I would also agree with that. In fact, when we met with Mr. Miller originally, he indicated that on literally a daily basis, he was getting phone calls from people on the production side trying to get some kind of financing, and he said he just didn't have any resources that were still available. And not only in the context of watching declining revenues, but we've also seen such an enormous increase in the cost involved both on the production and the distribution side that it is just becoming, some days it just feels like an insurmountable challenge trying to figure out how we're going to continue to keep this as an important and robust industry within the country.
I don't think there's any question that independent filmmakers have difficulty raising financing. That's been true at least in my 25 years in the business. I think it is telling, though, that the association that represents more than 90% of the independent film producers in the country has filed testimony against this proposal. So it's just not the big studios that are opposing it, Commissioner. It's the very people who others contend would benefit from this. And there is a whole host of reasons listed in their testimony as to why this particular financial synthetic product is not going to help them with the one thing they do desire, which is to raise capital. I don't think anyone can doubt the need for more capital and the need for risk management. We just don't believe, based on our experience in the industry, both from the studio standpoint and from the independent film standpoint, that this vehicle is one that is actually going to bring money into the system and is going to be free of the kinds of manipulation and really damage that these kinds of synthetic products have done in other industries. We don't want to repeat in our industry what happened in the mortgage industry. We don't want to repeat in our industry what happened in some of the other industries that were destroyed in the financial meltdown that happened. And while I appreciate when Mr. Halloran was in the business, there were 30 banks, there are only 9 today. Part of that reason is because people were engaged in wildly speculative synthetic instruments. And we just don't support bringing that ethic and ethos and financial model into our industry.
Yeah, I would just say that what you've had is a shift away from risky investments, period, throughout the entire economy. And one of the things I've heard from the many film festivals I've now been attending is that having a price discovery mechanism for what a box office might earn for a film that's already made, I'm not talking about one that's being produced, but one that's already made, that would be an enormous benefit to those who want to get their films into theaters and into distribution.
My time is up, but Mr. Pisano, you had said in your summary of your statement that you were concerned about if word got out that someone was on the other side of a film that they had, that it would be devastating for them. We, as a regulator in the exchanges, take a great deal of pains to make sure that individual positions do not get out. And that probably much to the consternation of some of those folks that would like to know that information.
Thank you, Commissioner Dunn. That's actually in Title 8. So if you want to go to Commissioner Summers.
Thank you, Mr. Chairman. I think I have a number of very specific questions about how the industry works. I think we've all made it clear that we are in the process of learning about this industry and how these products actually may be used. And so one of my specific questions for Mr. Pisano is, with just giving us a general idea of how many theaters there are out there, and when you look at the contract specs and the threshold of 600 or 650 theaters that a film would have to meet in order for a contract to be based upon that film, is that a low threshold? What kind of percentages of the actual amount of theaters out there would that be?
To answer your first question, there are more than 30-some-odd thousand screens in America. First point. That's not counting. That's numbers of screens. That's not the specific number of theaters or multiplexes. Most of them have 10, 12 screens. A typical studio release is 1,000 to 2,000, sometimes 3,000 screens in America. A typical independent film release would not meet that threshold. And so the very people that that contract wants to help probably wouldn't be able to avail themselves of it because of the limited release. So I think, and I could get you more detailed statistics, because I haven't looked at them recently since I haven't been in the studio business, but the overwhelming majority of total pictures that are released never achieve that threshold.
Okay. My next question is probably more appropriate for Mr. Jacobs with regard to how many films you anticipate having contracts on at any one time. How many films meet that threshold? You know, will there be dozens of films at any one time that you're offering contracts on?
Yeah, there are approximately, I think the number is about 500 films every year, of which about 150 are wide releases. Our intent is to, at the very least, trade all the wide releases. We'd also like to go to some of the smaller films. It raises other questions, and in the beginning, we've started with the wide releases. So since our contract generally lists a movie 6 months in advance, there are 150 a year. That means we'll do about 75 at any one point in time.
Commissioner, can I just elaborate on that in one respect? Of the 150 films that are released, wide release, the overwhelming majority of those are films from the 6 studios that I represent directly. The very people that would be prohibited from hedging by virtue of the conflict of interest rules, and arguably the very people who are not looking for this kind of financing. And conversely, the people that might arguably want to do it, the small independent filmmaker, they don't meet that threshold. So this is to put it somewhat pejoratively, this is a product in search of a solution that doesn't exist.
That brings me to another question with regard to the financing and this concept of investing in a movie on a blind, or investing with a studio on a blind basis. How would somebody who has invested on a blind basis be able to hedge if they don't know what movie they've invested in? So what contract would they buy? They'd just buy all of them?
No, they would not. Financiers, when I use the term blind basis, they will agree with the studio that they will finance their next X number of films, so 15, 20 films. And so at that point in time, maybe film 11, 12, 13 is not known. So that's investing on a blind basis, and they may choose to invest or be contracted and required to invest 25, 35% of that film's cost. So the way I see the product being able to be used by those investors is as the film gets closer to its release and there is more tangible evidence about that film, there are trailers that are put out and advertisements that are put out by the studios to market their films, that those trailers in effect will start to inform the audience about whether they want to go see that film or not. There's many television shows, blogs, et cetera, where information is freely traded, maybe to the frustration of the studios. And that can be used that if an investor has invested in that film and they think that that film is not going to perform, for them to go to the market to try to short the contract to see if that's cost efficient for them to do that. Where I also think that you have a movie like Avatar, is probably the best example that I use, where the people that I speak with at 20th Century Fox were 100% bullish on that film. And so there was a difference in the market as far as Fox being very positive, where people in the marketplace were saying, I'm not so sure about that film, and that's where I see a market developing. How deep it will be, what the price points will be, that's something I can't project, but I can see that possibility of that condition existing on a number of films.
Okay. Thank you. If I could just follow up real quickly on one point, just real specifically. If somebody is investing on a blind basis and investing in a studio's maybe next 10 films, as you said, but not knowing what those next 10 films would be, at what point does the investor find out what those next 10 films will be? I mean,
typically at the green lighting of the film, so the investor will know that it's in the slate. So as it starts production, then the investor would know that that is one of the films that's being included by the studio in the slate. And sometimes that is contracted to be sequential. Sometimes it's a selection process that goes on between the studio and the financier.
Okay.
And in many cases, the studio doesn't finance their films, such as sequels and things that they have very high expectations for.
Thank you.
Just as a clarification from staff, apparently they have their quick research. I don't know if this is off of some internet site, but 38,000 screens and somewhere between 5,000 and 6,000 theaters, to your question. No. Commissioner Chilton.
Thank you. Mr. Jacobs, you mentioned that there was an increasing group of people that were in favor of this, and one of the things that's actually surprised me is that we haven't got a lot of letters. I mean, we got 5 or 6 letters, and I do appreciate the ones that all of them that were submitted. There's only 3 that I'm aware of that were in favor of it, and they were well written and make good arguments. But one of them, from Jeffrey Sparks at Truly Moving Pictures, even says, quote, I cannot be certain of the utilization of box office future products by my organization. And he goes on, end quote. Then he goes on to say, but he thinks it's a significant opportunity for others. I would like, Mr. Chairman, if there's no objection, to submit some comments from 9 eminent professors all the way from UCLA, Wharton, University of Chicago, at the appropriate point. Record concerns about moving forward on this effort.
Absolutely.
And the other one I wanted to just be clear. Commissioner Dunn had picked up on my, it might be cool, but may not be business. May not fit the definition of business under our act. It's a big damn business. As a matter of fact, it's one of the, as I recall, it used to be only that food and films had a net positive export. And then for a while, the film industry was the only positive balance of export. So it's a big damn business. I want it to keep that way. I just want to ensure that we're protecting consumers and moviegoers alike from fraud, abuse, and manipulation. Ms. Newhauser, given your long history with making films, I mean, how long do these things generally take to make? I mean, when do you need the financing? Your contract doesn't allow hedging until a month before. The Cantor contract, Mr. Jacobs, it's 6 months. I mean, don't these films need money before 6 months?
Yeah, they absolutely need money before 6 months. I think the difference is that if financiers know that they have the opportunity to hedge later on, that it gives them greater comfort going into it. The lead time can vary anywhere from, I've got a picture right now that we're supposed to start shooting in July. I think we closed the underlying rights deal at somewhere in the 4th quarter of last year, with release scheduled for spring of next year. So, and that's pretty fast, generally speaking. But again, getting to the idea of sort of who it is would be looking for this financing. Studio releases are not necessarily either solely or even completely studio investments. There are a lot of people who go through the studio system, and frankly, it's also part of the reason why I think a lot of people had some concerns about having letters that were going to be publicized, because the studios control real distribution, and so until there was a decision made, it could put them in an uncomfortable position.
Okay. I'm not going to have enough time to get to my series of questions for Mr. Pisano, but let me just ask you this one that you can maybe respond briefly so we stay on time. you mentioned your time at Paramount when you first released box office returns. I assume that there's really one reason for that, and that's to show the positive as a marketing tool. Am I correct, or are there other reasons?
Absolutely, Commissioner.
Okay. So you use that in order to assist you in your further box office receipts.
Yes, and at that time, the notion of Monday morning reporting on who was the #1 film in the popular press was unheard of. The only people who knew were industry insiders. At the same time, we created a show called Entertainment Tonight, which for the first time popularized entertainment news. And so we used that vehicle as the launch pad, if you will, to promote the notion of we had the #1 movie. And in that time frame, we happened to have the #1 movie a number of weekends.
I noticed in USA Today on Monday there is an article which shows that Robin Hood had the biggest gross worldwide, but domestically it was Iron Man 2. And so this article talks about how the studios will use any little ability to market that they can and look for ads about Robin Hood saying it's the #1 movie in the world, even though it raised $16 million less than I Am 2. And so, I wonder, given that you're trying to get any competitive advantage, and I'll finish here, Mr. Pisano, whether or not look ahead in a hypothetical crystal ball and these markets exist, and would you, if you were a studio, advertise and try to market, say, the week before a film went out, that leading popcorn prediction market film as a way to sell your movie?
We look for any way we can to convince the public to come to see our movies.
So the markets themselves could actually influence the price ultimately if you were using it as a marketing tool, I guess is my theoretical question.
And I want to clarify that to make sure we use any tool we can that's legal.
Yes.
In order to encourage people to come see our movies. That's the business we're in.
Thank you.
I'm guessing then if there were movie futures contracts and they were trading well, somebody may even refer to them in the promotion of those movies.
It might happen, Mr. Chairman. It might happen.
Commissioner Amaya.
Thank you. As Commissioner Chilton noted, we have received a handful of letters, and while not many in number, they were helpful to me to understand a little bit more about your business. Terms like blind basis, slate deals, and renting distribution to third parties, these are all new terms to me. But one notable comment was since 2004, $14 billion worth of third-party financing has come into the market. You'd reference some other numbers, Mr. Halloran. Obviously, I'm trying to reconcile the difference between, Mr. Pisano, your statement that the studios won't trade this and therefore that is the center of gravity in this business, yet we're talking about $14 billion worth of third-party financing, which seems significant to me. Help me understand blind basis, slate deals, renting third-party distribution to what they are, how they bring money to a studio, and then the relevance of third-party financing. Mr. Halloran?
Blind basis and slate financing are very similar. A slate means the future output of a studio's films. So in a slate financing would be where a third party or a financing entity would agree to finance 25% of the next 20 films in the slate. And blind pool means that I don't have titles attached to each of those films that I agreed to finance. So I'm agreeing to co-finance them on a statistical basis, assuming they meet some qualifying film definitions, such as the budget is within this range. So all of that $14 billion, which is a very accurate number, was financings that were arranged using senior debt, mezzanine debt often, and equity from largely hedge funds and private equity and senior commercial bank lenders to co-finance I'll use, for example, 25% of Paramount slate through financings that were called Melrose 1 and 2,
Yeah,
or
let me
Fox's
interrupt.
slate.
Let me interrupt. Now, does that financing all these tranches of debt, does that go through the bank, or does that go directly through the studio, these deals? Do the studios arrange them?
They will often be arranged by the studios, and they would be arranged by independent third parties, such as hedge funds or different money managers. And so a money manager or a hedge fund or a senior debt lender may go to a studio and say, I would like to arrange financing to co-finance your slate going forward and negotiate terms. I want to hit on the term rent-a-system. That is a term that's generally used to say that the studio doesn't own any of the underlying economics of the film. They're just being paid a distribution fee out of all proceeds to perform distribution services. So Ms. Newhouser pointed out that many independent third parties use the services of a studio for distribution. That independent third party, what we might be calling an independent producer here, meaning a non-studio producer, would be using a rent-a-system through the studio to get their product to market.
And who does that? Who fills that role? Rent-a-system?
There many of the studios, there's a number of companies that you may not be household names, New Regency, Morgan Creek, Lakeshore Entertainment. These are what I would estimate provide maybe 30 to 40% of a studio's entire film slate that it releases in 1 year. If you want to think of them as being third-party feeders that are supplying films to the studio's distribution operations, and that's attractive to the studio to not only get additional product through their system that they can distribute, it also helps them because they're getting distribution fees that from a consistent source, oftentimes without an outlay of capital. So that $14 billion of financing was done for many studios. Virtually all of the studios had some form of it, but it was also capital that was provided to independent third parties, independent producers who were distributing their films using the rent-a-system of a studio.
This is fascinating. I'll wait another round of questions.
So that's my question. I was going to ask my fellow commissioners, you want another round? All right, well then I guess there will be another round, and therefore I guess I'll have a question or two. Mr. Pisano earlier said, I wrote some notes, there was three things, sort of whether this was a commodity. There's some question that you've raised about that. You talked about price discovery and manipulation. I don't know where we'll come out, but I suspect, given that the 74 Act is really very wide, it's likely staff is going to recommend to the five of us that this somehow fits into that broad colloquy that was going back and forth earlier. On the price discovery point, there are a lot of things that are off of indices, but I'm going to have a question probably for Mr. Jacobs. I'm tying off of what you said, Mr. Pisano, but is that we have lots of indices, whether it's the housing index or the Eurodollar index, or a lot of indices that things are off of. But the observation here is that this index isn't about the value of something. I think that's sort of it. I mean, if it's a housing index, it's the value of houses. If it's a Eurodollar, it's an interest rate, which people would say that's the exchange of money. And I take the point. This is something different. This is aggregating all of the box office receipts. It's not sort of the value of something that trades. What's your reaction to that point?
Well, we think it is a value, that there are real economic flows that are associated with those box office. And in the case of our contract, we take that box office and basically slice it into a million pieces. If we looked at how those pieces, the economic value of those pieces flowed through the waterfall of investing in a film, you could trace those out.
But whereas the oil index, a Platts index or something, people actually buy and sell oil. I'm trying to make your point for you, Mr. Pisano. I'm just trying to understand. And in the Eurodollar, somebody actually borrows money, and there's interest exchanges hands, and feeder cattle. I could go through the other indices. Houses, people buy and sell a house. Does anybody buy and sell a box office? That's your point, right? Just trying to.
Yes, it is, Mr. Chairman.
Yeah, there are.
I don't know whether it's legally relevant to us as a commission, but I just still trying to understand.
Where there is an economic risk, in this case, the box office value will flow. For example, theater owners, in rough numbers, get half of the value of the box office. They are exposed to that value. They are to be recipients of those funds. Therefore, the risk and the commodity, if you will, that's being traded is the actual box office receipt.
So I guess your point of view is if we determine it's a commodity, even though that the index doesn't have like a physical, it's not a cow, it's not a house.
Yeah, CPI is just one example. I mean, Mr. Schultz made reference to several examples, but no one owns a house that is tied to any of the real estate indices. No one actually owns the CPI index. However, there are people who have risks that are related to those particular indices, and that's our view of box offices.
All right, so now let me turn to the third point that Mr. Pisano, I think, if I wrote my notes right, was the manipulation point. And I'm not so much into whether rent tracks, because apparently they collect data from like 98% of the theaters or something. I'm more into the point that Mr. Pisano raised that, this is an artistic product. I mean, the CPI index is across probably thousands of communities, and it's hard to discern that any one individual or group of individuals can push around that. Now maybe you could say something different about the oil index, maybe, but in terms of the ability of some group or individual to influence the box office receipts of one particular movie, I think that's the point there.
Excuse me. I think that, again, Mr. Schultz made reference to this. I think the narrowness of the contract is part of the discussion, certainly. The ability to manipulate a contract, I mean, the unfortunate reality is our industry through the years has very colorful examples of folks who have taken, who have been able to manipulate all sorts of different markets. So the fact that some criminal behavior is potentially there.
Let's say, and I don't expect you to have the knowledge that Mr. Berkovitz had about our statute, but let's say that the staff said it's a commodity and that we have other indices and that sort of, and maybe they even said this Rentrec thing works, which they haven't yet, but we've got to sort through that. But somebody came in on an index that was similar on, one person's house, and let's say that's a commodity. I'm just hypothetical, and it met all the other tests. If it's a very narrow contract on one movie, that's the question I think that Mr. Pisano is raising.
Yeah, and I guess I would just say to that, and again, I think this was addressed in some of the earlier comments, a $50 million movie is typical for the size that we think we'll be trading with these wide releases. If an average ticket is $5 or $10, pick your number, you're talking about 5 or 10
I would
million.
Pick 5 for me, but it's
okay, well, there you go.
They charge me more.
That's the actions of 10 million individuals going to see a movie or not going to see a movie. Certainly, marketing and these other things can influence those, but the reality is that in terms of the ability to drive 10 million people to see a movie or not to see a movie, they certainly can be influenced, but to actively manipulate that in a very controlling fashion, we think can be readily surveilled.
All right. Thank you very much, Commissioner Dunn. I hope it was all right that I used your points. I'm just trying to learn here. I don't.
We'll cross-examining him later. A lot of the communications we've got are concerned that this is tantamount to betting. And the reality is, in the futures markets, it's a zero-sum game. Somebody wins, somebody loses. So we may call it hedging or speculating, but the fact of the matter is there's always a winner and there's always a loser in there. I'd ask all of you if that is of concern to you. And do you really see it as betting, or is this a way to hedge. The second part of the question that I have is probably to the exchange, but I'd like to hear the comments from the other, is how do we ensure that the barriers for insider trading are in fact enforced? What is the exchange going to do to ensure the integrity of this contract?
With regard to the first comment, we are very concerned. In my opening comments, I referenced that we agree with the MPA in terms of having relatively small spec limits so that we can make sure that the activity in the market is a representative and fair price market. So, and be happy to answer specific questions on that. With regard to insiders and barriers, one of the things I thought was interesting in the congressional testimony was the opinion of apparently a couple of the congressmen who thought that the whole notion of any form of insider blocking was not appropriate because it's not generally part of our industry. Having said that, we do believe, and we've put together a list and shared this with the staff. We have identified a number of information elements that we think are worth monitoring. Again, we've shared that with the staff. We can monitor these activities. I don't want to go into too many of the specific details here in a public hearing, but in the discussions with staff, we think we have a very good ability to monitor these items. There may be other items that we need to add to this list, and basically enforce the contract to make sure that the market is a level playing field.
That implies that there is a quid pro quo with that industry group. How are you assured that you're going to have that ability?
By quid pro quo, you mean that they are somehow cooperating with us? Yeah. One of the things we firmly believe, and I think Mr. Pisano would agree with this, is that the industry is in the business of making good movies. They do want to promote their movies. They've said they want to market every film so that it reaches its maximum potential. And I think that the activities that we've identified here are activities where they are taking actions contrary to that interest, where they do something to harm the film. We know that they're trying to do everything that can help the film. And so what we're mostly concerned about is where there is a short position in the market, either direct or indirect short position in the market, and then some action is taken to harm the value of that film. Again, we think in our discussions with staff, those are very easily surveilled, those events.
Short answers to your question, Commissioner Dunn, are yes, it's betting. Yes, there's going to be losers, and yes, we're very concerned about that. We should be. We're not interested in having people lose money in our business, especially people who are not sophisticated investors. And so, and then finally, the manipulation, the very fact that traditionally, as I understand it, and I'm not a commodities lawyer or trader, there are no insider rules. The very fact that these exchanges have had to craft a jerry-built system of insider rules that are going to apply to an industry that doesn't want them and doesn't want to be part of them and could require compliance issues. And I was the general counsel of Paramount for a period of time. This is a nightmare. And that's another reason why we think this is ill-advised and wrong.
Oh, well, I guess I'd sort of go back to, a baseball analogy, which has to do with, what's considered a good batting average in baseball would be great in the film industry. So, as to whether or not it's betting, I guess that would be whether you think that, you're betting going into an initial investment as a studio to begin with. So I do firmly believe that this is an opportunity for people to hedge some risk and hopefully to be able to bring some new capital in.
I think the production and distribution of films is almost betting. It's a very risky business. Every film that is produced and released probably costs a studio now averages about $100 million. It is a hits business. The majority of the films do lose money, and the studios are in that business, and other financiers choose to participate in that business, and I think it would be very valuable for them to have a product to hedge or to go long would encourage investment into the business, and I think that's very much what's needed in the industry at this time.
My time has run out, so Commissioner Summers.
Thank you. I would like to explore some of the issues with regard to Rentrack and ask you if you could just walk us through, in your testimony, you talk about how the box office receipts have, in your review of the history of the box office receipts versus what the studios report as earnings, have been, very close and within the minimum tick size of the contract. But what happens if it's not? And if you could walk us through from the exchange's position in your contract rules when that falls outside of that number.
Yeah, so I don't think we should be prescriptive in that simply because we don't want to create a target where manipulators can take advantage of the statements I'm going to make here and say we can rely on that fact. Having said that, let me say this. If we, and I believe this was in either my congressional or written testimony here, if it turned out that the studio-generated numbers were either unavailable or unreliable, we would do what Mr. Schultz said and propose an index that is based strictly on the electronic calculations of Rentrack. We can eliminate all the variability here by just simply substituting that. Now, the reason we chose not to do that is, again, I think Mr. Schultz made the statement, we think the industry, the studio distributor-produced number is actually a reliable indicator and respected by the industry, and we've seen nothing to suggest otherwise. So, yes, if it turned out that as a result of the contract review process staff is currently going through, we shift strictly to the exclusively electronically reported numbers, we would make that adjustment in our contract design.
Is there a reason why you chose not to do that in the first place? If the numbers are historically so close together, why would you go through these hassles?
We wanted to make friends with the MPAA. We were afraid that if we came out with electronic-only numbers, I'll give you an example. Now, Mr. Pisano has said that it's important that these numbers are as glorious as they can possibly be. In the case of Iron Man 2, the electronic reported number was $156,745,024. The studio reported number was I think I've got this right, $159,159,871. The electronic number is less. And we thought the studio would be very angry if we reported a lower number, so we went with the studio number.
Is that usually the case, where they're less?
So yes, because there are, we call them non-reporting theaters. I think Mr. Schultz referred to them as, I forget, there's another term for them. But yeah, the call-around theaters. So, and again, in the case of Iron Man, which is a very widely distributed movie, 4,204 electronically reporting theaters, 176 non-reporting. And because they're non-reporting, they're generally smaller, and you can estimate them with a reasonable degree of certainty.
Thank you.
Thank you, Commissioner Summers. Commissioner Chilton, and I apologize, I do understand that Mr. Pisano has either a flight to catch or something, so we might lose you before, but hopefully not.
Thanks, Mr. Chairman. I'll try to be brief, and I'm going to direct some of my stuff to Mr. Pisano, so you can be brief, too, and catch your flight. I'm not sure I agree with the Chairman that, it's a foregone conclusion that, the underlying is a commodity. I think you have to...
Let me say, I was saying that I would think that under the 74 Act, it's quite possible staff will say, that it's generally been over 30-some years read expansively. I'm saying just what staff might, that's all.
Okay, thank you. I mean, and I'm sure they will because we have an excellent general counsel, but you have to look at the Act very broadly, which means Section 3 also. And, I think that, the definition could be meaningless if you would just include anything that doesn't have a true underlying. But again, we'll wait for some of our advice from counsel. But, this is not like a corn or a crude contract where multiple people control the contract. They have an influence. And I know there's some debate about control, but I think it's, the studios primarily who have a major impact on this. Mr. Pisano, here's where you can be helpful and brief. This is a typical movie studio organizational chart. You're not going to be able to read it probably, right? So maybe I'll go through. But if you look at this whole chart, you have production. They have an impact on box office receipts, obviously, right? Acquisitions, This is what acquiring the rights to films and scripts and stuff, so maybe not so much. So that box, no. Theatrical distribution, sales, marketing, absolutely, 100%. Home video distribution sale, does that have anything to do with the box office receipts? Is it home video distribution sales and marketing? Well, marketing.
Yes, sir, because first of all, the majority of the receipts for a given movie to the distributor don't come from theatrical; they come from downstream markets.
Okay.
And so, yes, the home video distribution marketing people are intimately familiar with what the movie is about, how it's going to do, we think, and have all of the inside information that flows around the studio.
I'm sorry, if I could just interrupt.
Yes.
Acquisitions can be for completed product. It's
Okay.
not just the acquisition.
So it
of
actually
scripts.
could impact the box office. Okay,
Yeah.
good. Sorry, cross that off. Okay, then home video distribution, well, that's what we just did. Television distribution, sales, and marketing. Mr. Pisano, would that affect the box office returns?
Well, it doesn't
Or is
affect
that an
them,
after product?
but they're very concerned about how the movie is going to be.
Yeah, but
and
it might
so
not
they're
impact the opening weekend or something.
Probably
so we'll
not.
Cross that one off. And then consumer products and merchandising.
very
Would that
much tied to box
Very much,
office.
because the people that make the Shrek doll or whatever. Okay, business affairs and legal, anti-piracy, subgroups are anti-piracy and communications. Business affairs, legal. I really don't know anything specifically. Can you enlighten us? Would that affect the opening box office?
Well, they certainly will have inside information as to how.
They couldn't trade. They might not have an impact on.
Correct.
You think no, Ms. Newhauser, too?
No,
Okay.
they're just dealing with
Okay, so we're
the
gonna-
contracts underlying.
We'll cross it off because they'll have inside information. They couldn't trade, but theoretically. Okay, and then the last one is finance and administration. I assume the finance part of that absolutely would have an impact. The administration, the HR, the facilities, and the information system. So if we look at this whole organizational chart of a studio, essentially you have the television distribution, sales, marketings that would be excluded, from, they'd have inside information. The business affairs and legal folks, and then the janitors and the technology people. But the rest of this entire organization, thank you, Clay, the rest of this entire organization is built towards making a movie and a box office return. And so, my concern, as I said at the outset, is that they have such control of the price that I worry that if they're involved in it, they could potentially have an undue influence. And going back to the letter of the law, that they are a party that can control, doesn't mean 100%, but they can control the contract, and the contract is based on an occurrence. The occurrence is the box office future. So if you say, well, maybe he's right. Maybe that dude just made a point, and so get them out of it. Don't let those guys participate in this market. Then the question goes back to what the chairman was asking earlier. Well, is it a legitimate hedging vehicle? I mean, if you take the studios out, who are the 800-pound gorilla in this, we've already talked about how this may not really help the independents. So is there a legitimate hedging vehicle here? And you go to, and that's a significant part of our law also, where it said it has to be, and this is Section 3A of our Act, it has to be used for managing and assuming price risk. If it's not, it doesn't meet the criteria. So Ms. Newhauser says, this argument that, which I understand, but, I'm not sure I buy it 100%, sort of the Field of Dreams argument. If you build it, they will come. They're not going to tell you right now that they want to use these markets because they're scared of the big bad studios. But once you build it, they'll be there. And I'm just not sure. It's a determination by the commission, by us, as to whether or not this will be used more than on an occasional basis for managing and assuming price risk. So it's just an outstanding question in my mind. And I'm not sure that was a great movie, but I'm not sure that this is going to pass the legal hurdle for us. I feel bad I've used all my time on a diatribe, but I'm not going to have time to ask a question now.
Commissioner Amalia.
Quote Animal House. It's not over until it's over, right? Bart, finish up.
He's giving you time.
Knock yourself out.
Well, Ms. Newhauser, what about that? I mean, and when you all met with me, and I assume the other commissioners, thank you, Commissioner Amalia, when you all met with us, you sort of said the same thing. You said, without, I hope I don't give away a confidence, but I mean, well, we know lots of people at the studios, and they really want this thing. We can't tell you who they are, but they really want it, and they think it's going to be great. I mean, it's a little tough for us to, make a decision on a legal basis on like a secret society.
Well, that I think is a separate issue, which is if, our meetings were conducted in confidence. These were at very high levels. And so I take as reality the people who met with us and said that they had interest. I don't really understand it, and I never have really understood this idea that if it is so bad for a studio to think about so-called betting against their own pictures, who in that value chain at the studio is going to be actively working against the best box office possible? Everybody's job in the studio is to maximize the box office. So I've never really understood that idea that somebody's going to go and tank it. You've got, $150 million invested in a movie, and for some reason, some guy in a box over here is going to say, I don't want this to go down. That's how you lose a job.
So I accept your argument. They're not going to use the market. So who's going to use these markets? How are they going to hedge?
I think we're talking about the $14 billion of other investors. It is not just the studios who invest in movies that
So who
come
are they
out
going to
of the
do?
studio system.
I don't mean to cut you off. I'm sorry. You want to finish? I'm sorry.
No, go ahead.
Okay. So, really, we've got to make this decision. We got 3 letters, Mr. Jacobs, and one of them says, I can't guarantee we're going to do it. So how do we know? Blind faith, we say, it looks like they're going to use it. Maybe they will. What do you say? Let's flip the coin.
Well, I think Mr. Schultz will recall much better than I do. I've been in the industry since the mid-'80s, and my recollection is that the standard when the law required the economic purpose test was we did get letters. I think it was about a half dozen in a typical contract. And to my recollection, every one of those letters had the disclaimer that the use may or may not occur. I think if we go back to the standard post-'74, pre-2000, if we go back to the standard, the letters we're getting now would certainly under the old standard, would have been germane. I do think that the nature of this dialogue and the MPA's position has had a chilling effect on folks who would like to come forward. I'm thrilled we've gotten what we've gotten. And if this process continues and the contract moves forward, I'm sure you'll get more. We're getting new letters every day. So, there are folks who are in favor of it, and I think the chairman's asked the question from the beginning, how many does it take?
Yeah, I don't mean to be dismissive. The letters, as I said earlier, I think were fairly articulate letters and helpful to us. So if there's this big group of people, or if there's a group that's, the silent majority, they got till the 26th, and, it's the 18th, 17th, 19th today. So, they got another week, I guess. But, quite frankly, this issue, as the chairman described, earlier and Mr. Schultz elaborated on, this thing was out there for a long time. Now, on the DCM status, whether or not we approve you all, it wasn't on the specific contract at that point. But, Goldman, all the Bank of America, Bank US, all these financiers, yeah, okay, I didn't hear them either. So it seems to me they've had a lot of time. So maybe we're going to get a lot in the future. I can see where this might be useful to some people. But whether or not that's more than occasional, I really don't have anything other than, your words that it's going to happen. Did you want to make a comment? I'm sorry, I left you out.
I would, please. Thank you,
sir.
Thank you. I don't think that the studios are first movers in very much of their business. They have a very challenging business. They have very challenged returns, especially in today's environment. So I understand Mr. Pisano and the people he represents concern that this could possibly be a negative, and therefore let's not have the market go forward. That $14 billion in financing had never been done before. It was the availability of capital, and it was breaking new ground in using sophisticated Monte Carlo analysis to try to project film performance. So as a former banker, and in trying to understand this product, it was complex for me. It's not something that I deal with. So to have bankers or a flood of bankers or individuals take a position in something that they don't understand and that is very complex is understandable to me, because I had to be educated on it to form an opinion and to be able to voice that opinion.
That's helpful. Thank you. Mr. Pisano, and then I'll finish. You want to comment?
Well, I'm no disrespect, Mr. Chairman. I would miss an airplane, but I've been invited by the Vice President to a state luncheon for the President of Mexico, representing our industry, and I'm supposed to be there now. But I would be pleased to answer any further questions in writing that the commission, individual commissioners may have, because this is very important to us. It's very important to the entire coalition that we represent.
We appreciate your attendance at this hearing, and we understand if you have another thing. I don't know, in 30 seconds or something, you can just... No? Did you?
No. Other than thanking again Mr. O'Malley for being very gracious for this time.
Mr. Pisano, you're welcome to leave. The only worse thing than getting invited to the White House is not being invited to the White House. I want to go back. I was informed by staff that the Rent-Track number and the box office receipt numbers are critical to other merchandising deals in this business, DVD sales, other things. So I'm trying to reconcile how Mr. Pisano's comments about insider trading and the threat of that, and his written comments talked about how this is ripe for manipulation and almost inevitable, it seemed from his written comments. How they do business doing deals on further, on downstream products, if that's a term that you all use, but downstream products and based on box office receipts that they seem to control. I mean, isn't that a concern in the industry of whether that number is valid or not, or do they use Rent-Track? Is that how they do their business? So I'm trying to reconcile how this business functions without a reliable number, if Mr. Pisano's correct.
It's my view that the number that is reported is reliable, and it's used in many ways. Mr. Pisano mentioned the marketing of films, highest Tuesday ever on a rainy Tuesday weekend, performance that they use to market their films. Video performance is highly correlated to box office, and the industry and people who operate in the video segment of the industry use those results to see what is happening in trends and how many videos they should buy if that correlation is still holding as high as it used to. Pay television agreements on Showtime and HBO are a direct function of what we talked about was being rentals, which is a function of box office, and exhibitors split up the box office pie according to often specific calculations that are pre-agreed with between distributors and exhibitors. So if I have a higher box office performance, I may have a changing what's called a settlement rate that determines rentals, which is what determines how much HBO and Showtime pay for my films. Whenever free television distributors such as CBS or networks begin their negotiations with studios, they talk about the license fee that they will pay as a percentage of box office. Box office is the key, and studios often use their box office results for market share data, which they market as well. So one of the ways that number becomes very efficient is when someone is over-reporting, then you have, and especially in the studio system, then you often have the 5 other parties that are part of that studio system questioning their statement. So it's what our industry really focuses on, and it's to me has been a very reliable number. There's also many websites that use box office data.
Mr. Jacobs, you had mentioned that you had some additional data regarding the fidelity of the Rent-Track number and in your opening statement. Can you provide that to the Commission?
Yeah, and just to carry on with Mr. Halloran, I would just say that one of the things we discussed with staff was we did research. Hollywood is filled with litigation based on disputes over accounting numbers. And we are unaware of litigation based on this box office number. Does that mean that it's never occurred? I'm not saying that we've been completely thorough, but we think that's, in an industry that has disputes over accounting, this does not seem to be a central focus of those disputes. And again, we track on a form, and we provided this to Commission staff. We do track a very detailed analysis of the actual numbers that come out. So on average, the error is about 13 basis points, or 0.1% is the difference between the studio number and the estimate that we would come to if we had an independently calculated or proprietary index. And we have done that, for about 1 year's time. And so we think the rent track numbers and the studio numbers are actually, for various reasons, very highly correlated and accurate.
Yeah, well, there was Mr. Pisano made a quote, and I'll certainly submit this in writing for him. His quote was, "It's a nightmare to control insider information," and I'm troubled by that. Obviously he had to leave, but I'll ask him in writing and what that may mean and how bad it is. But I'll follow up. But if anybody has a comment on,
well, I would just comment on one thing. I think that one of the issues we have with MPAA's position in the letters is that they cast a very broad definition of insider information, and I think that's core to this discussion. The letters have said, I don't know if it's in the 11 May letter, but letters have said that, in their view, every director, every talent agent has some knowledge of the fact that an actor has a disease, or they've cast this notion of inside information very widely. We don't. Again, in terms of the staff review, we've narrowed it to 3 very basic points.
Well, on a very broad basis, I would be concerned from an SEC perspective for all of these publicly traded companies if he legitimately believes that his membership has problems with insider information and how it's being used. But in any event, whether, getting back to Mr. Jacobs' point, whether you're talking about, directors' information or whoever, I think we've all pretty well established at this point that whether it's Twitter, whether it's Entertainment Tonight, whoever it might be, there is just a massive information that is currently available to people. So, a director having information about a cast member is so dated at the point that you're actually approaching anything close to a release is, both known and fairly irrelevant, I would say, at that point.
If I can just ask one brief question. If you could submit any data you have on kind of the downstream value tied to the RENTRAC number, if there's any way to capture that. It was a pretty interesting discussion we just had to understand what that value is and how important that the fidelity of the RENTRAC number, the box office receipt number, whatever they tie that to for commercial downstream purposes.
And just as a point, it kind of missed half of the additional revenue, which is that international box office and therefore all of their ancillary revenues are also generally very highly correlated with U.S. box office as opposed to what we saw with Robin Hood, where it generally has a very big impact on how it performs internationally.
May I make one comment just about your insider information question? I think there's another side of this that I'm confident just absolutely scares the studios to death. And that is that film won't be turning out well, and in pre-release screenings or around the industry that it won't be performing well, and they're trying to keep that information as close to the vest as possible to try to get the film out and be released. Studios, even at times when they're in that position, don't even provide this film to be available to be reviewed by third-party reviewers, one of their biggest marketing sources. And so I think that there's a lot of information, and I'm very sympathetic to the studios in trying to control that because they have a huge investment in this item of product that is very risky.
Well, we certainly wish them all the best in every movie they make and wish them great success in international. It is a major trade and business for us here in the United States, and we wish them every success on every movie, but they have put up some stinkers.
A lot of good lines here today. I want to thank the panels, but this is just a yes or no. Are you familiar, Mr. Howard, because you seem to be closest to this finance, does anyone do this same hedging that we're talking about here in the over-the-counter derivatives marketplace, which is presumably allowed? So just curious, do people do transactions?
Not that I'm aware of, not in any organized market that I'm aware of.
So you're not aware of any box office receipt over-the-counter swap?
I am not.
Then, Ms. Newhouser?
No, I haven't.
But you still stand by your earlier view that somebody will use this thing to occasionally hedge? And when, it's completely unregulated. Nobody's using it to occasionally hedge in the over-the-counter derivatives marketplace, at least to your knowledge.
To my knowledge, there is no organized market in which people are trading, but one of the, I'm highly confident that a hedging tool that could affect box office performance, since all of these markets are regulated to this, would be very attractive to the industry. To the point what extent they'll use it, it all depends on the price point and the volume of the contracts that are traded.
I want to thank this panel. It's been very helpful to the Commission. We have another panel. I apologize to those who have been waiting to come up. But as I won't officially have a break. I'll just have as people swap in and out, if that's all right. Thank you very much. If I could ask, oh, I can do this. Or do this. Shh. We're pleased to have with us Michael Burns from Lionsgate, Scott Harbinson from International Alliance of Theater and State Employees Directors Guild of America, Skylar Moore, thank you, Skylar, from Strzok and Levan, and Robert Swagger from Media Derivatives. And we'll go from right to left this time, and your written things will be in the record, and I thank you for your patience that we're running a little late here.
In the interest of time, instead of taking 5 minutes, I'd just like to give the Commission, if I could, just sort of a brief background on myself. I started actually in 1995. I co-founded the Hollywood Stock Exchange, and then years later, before actually 9/11, I sold the Hollywood Stock Exchange to Cantor Fitzgerald. I was an independent producer, actually towards the latter part of my career as an investment banker. I ran the media practice for 9 years for Prudential, and before that I spent 9 years at Shearson Lehman Brothers and went through 9 name changes in 9 years. And in 1999, I went on the board of Lionsgate, which was a tiny little independent producer and distributor, a market cap of around $60 million. We've grown the company. My partner, John Feldheimer, who ran Sony Television, and I came over full-time in early 2000, so we've been there about 10 years. Today, Lionsgate is a diversified media company owning channels like TV Guide. Epix is our pay television channel that we own with Viacom and MGM. We have a very diversified slate of motion pictures. We put out about 14 to 15 movies a year. We've had numerous Academy Award nominations and wins. We also have a very robust television business. Some shows that you might know would be Mad Men, Nurse Jackie, Weeds, and that's what we do.
Thank you, Mr. Burns. Mr. Harbinson.
Good morning, Mr. Chairman. My name is Scott Harbinson. I'm an international representative with the International Alliance of Theatrical Stage Employees, and I'm here today representing both the IATSE and the Directors Guild of America. I hope my presence will underscore the grave concern we have about the impact of movie futures contracts which are pending before the CFTC. IATSE is a labor union that represents 110,000 members in the entertainment industry who work in the motion picture and television production, live theater, and trade shows. The DGA represents over 14,000 directors and members of their directorial team who work on feature films, television, news, sports, commercials, and new media. The realities of our business are not easily understood by those outside of it, so let me begin with a few of the specifics I hope will shed light about our concerns on the MDEX and Cantor Futures applications. The majority of the middle-class wage earners working on the creative side of our industry do not hold a regular, full-time Monday through Friday job. Ours is a freelance business. We move from employer to employer, from one project to the next. Our business model recognizes and accounts for that uncertainty by providing another type of security in the form of residuals. These residuals, which come from the exploitation of our work in secondary markets, such as DVDs, free and pay television, and new media, help people in between jobs, either directly or through contributions to their health or pension plans. Not surprisingly, there's a high correlation between box office success and downstream revenues, and hence the residuals generated in these markets. The ability to place lucrative bets on a film's failure by shorting it puts the commercial success of the film at an even greater risk. This new risk would not be generated by the people who spent years and invested millions of dollars in making the film. It would be generated by those who are likely to have no real stake in seeing the film succeed. Their goal is simply to make money for themselves. What will follow will be diminished downstream revenues. When that happens, our members will suffer. Additionally, the lower revenues will dampen reinvestment, which leads to decreased production and fewer jobs in the future. It's hard for us to conceive how the CTFC can allow a motion picture, which is in fact an experience, not a commodity, be monetized and treated like grade A wheat. At a fundamental level, we believe that you need to consider whether the motion picture industry will actually benefit. Will there be a broad and greater economic gain as a result? And what about market manipulation? We believe that as regulators, your first duty is to the welfare of the general public and to the industry stakeholders, not to speculators on the margins of the industry looking to make a quick buck. Relative to a bushel of corn or a barrel of oil, there's no question that a contract tied to a single motion picture's box office performance would be far easier to manipulate. It's been suggested by Cantor and MDEX that smaller films would be the type that would most benefit. Actually, it's the smaller films that would be most vulnerable to that manipulation. The initial theatrical success of a film is all about the buzz created. Why would you create a new economic incentive for gamblers and speculators to intentionally produce negative impressions of our films? The MPAA and IFTA represent companies whose releases comprise more than 95% of the motion pictures that would be subject to these exchanges. IATSE and DGA represented crews work on virtually all of these productions. So you have almost the entire motion picture industry, the purported beneficiaries of these contracts, absolutely opposed to them. The proponents of these contracts are the ones who will be the largest, if not the sole beneficiaries. And once again, the Wall Street guys stand to make millions, while the working class, and do so at the working class people's peril. We've just seen the result of the financial industries helping other economic sectors with new and exotic financial instruments. This help has resulted in dire consequences for the economy and tragic outcomes for the middle class who've been fleeced through no wrongdoing of their own. The motion picture industry has reliably provided international trade surplus every year since its founding, provides hundreds of thousands of good middle-class jobs that provide health insurance and retirement benefits. Our industry doesn't ask for bailouts, and it doesn't need any help from Cantor or MDEX. We seek only to grow and prosper without being imperiled by profiteers who have no stake in the continued success of our industry. Just because these contracts may benefit Cantor and MDEX and indulge the starstruck gamblers for whom these things are created doesn't mean they're a good idea. Cantor and MDEX seem to have adopted the line from Field of Dreams. Build it and they will come. But more aptly, that line translates to trust me. Well, I don't trust them. The working men and women I represent don't trust them. The directors don't trust them. And the motion picture companies that have invested millions in this industry don't trust them, and neither should you. Thank you.
Thank you, Mr. Harbinson. Mr. Moore.
I'm Skylar Moore. I'm a head of the entertainment department at a large national law firm, Strook and Levan. I have done this for a living for 29 years. That is what I do, film financing, and I represent the money coming into Hollywood. That's what I do for a living. I'm also an adjunct professor at the UCLA Law School and the UCLA Anderson Business School teaching film financing. I am the author of a book called The Biz, which is about film financing, the author of a treatise called Taxation of the Entertainment Industry, and I am the author of an article that came out 7 years ago advocating this precise technique to raise financing for Hollywood called Betting the Box that I published 7 years ago. I am here to help this industry. I am here to help the guilds, to help the unions, to help the studios, to help Mr. Pisano. I'm here to raise money. I will tell you on the front line that first of all, Hollywood is in deep trouble right now. There has been a massive withdrawal of capital from Hollywood, massive. Revenues are down. The equity financing to New York has backed off, and the reason is because there is no objective, clear, transparent method to value what you own. People don't want to invest and simply get an opaque accounting statement from, that they're worried about Hollywood accounting. And what this box office technique brings, which is what I advocated 7 years ago, open the paper and there it is. Now you know what it's worth. You see it the next day. You can trade it. It's obvious. It will bring billions of dollars of capital to this industry to help the crew, to help the studios. All you have to do is look back to before there was public trading on stocks, how much capital came into the corporate sector. And then once there was public trading, multiples of capital compared to what it was when I believe it was 1910. Take a look at a private company versus a public company now and how much easier it is to raise capital when you have publicly traded stock and you can open the paper and you see what it's worth. That's all we're asking for, is so that investors in this industry can have an objective, clear, transparent way of knowing what they own. My hope, actually, is that the studios will take this a step further and do all investments, the slate financings, the blind pools. They really should tie all investment to box office results because it's an objective, clear result that will bring money to the table. Will they do it? Absolutely they will do it. They've been doing this for years, 29 years. This is what I do for a living. I help the studios hedge. They're shorting their film every time they do a split right transaction. $14 billion in the last 8 years of slate financings with New York. What's that? That's shorting their films. That's shorting half the film. They can't stand here and say they wouldn't do this. They've done this for 29 years that I've been in practice. The co-production, split rights, pre-sales, that's what they do. This offers them a transparent, simple, efficient technique to do it. Every industry that has had a new exchange proposed fights it, almost without exception. Enron went crazy when oil futures were proposed. The Treasury went crazy when interest futures were proposed. This industry is making the exact same arguments that every other industry has made. Fear of the unknown, fear of what's new, and I'll tell you what's really driving it, right? What's driving their paranoia, and it's myopic, and it's wrong, but it's clear this is what they're concerned about and is driving everybody. They are concerned that if a film is tracking badly on the exchange, that theaters won't book it and the public won't go. Period. End of discussion. That's their fear, right? And here's the answer to that. Asked and answered. The Hollywood Stock Exchange has been running since 1995 and has not had a single impact on a single film attendance, theater booking, anything else. And you can go online right now and see how a film is tracking on the Hollywood Stock Exchange. So the information has been there. So that's number one. Number two is that there is a flood of other pre-release information that's available to the public. AintItCool.com website, Rotten Tomatoes, reviews, buzz. I mean, it's just an absolute roar of pre-release buzz. This will be a drop in the bucket compared to everything else that's out there. This will not adversely impact the attendance at a film. And I want to tell all the studios this and the MPAA that they have lost their mind on paranoia on this issue. And finally, overall, it's going to track. You made the comment that maybe it will increase attendance. You're right. That's not a joke. All right. To the extent that there's a film tracking badly, will be made up by the fact that other films are tracking well. And so overall, on average, it's not going to have an adverse impact. On average, if anything, it'll be a wash, if not better. Right. So I think that they've got everyone excited about this issue. They've got this gentleman here excited he's going to lose jobs. I'm going to bring you billions of dollars. They've got IFTA, which is the Independent Film Independent Film and Television Alliance. They've got them excited in joining the MPAA. I represent a lot of independent film companies, and IFTA did not come talk to my clients. They didn't come talk to me, right? And again, I guarantee what happened. MPAA said, "Oh my God, a film might track badly. It might hurt you." It's like, come on, guys, right? Stop with the paranoia. Every other argument, every single one that they've made, is make weight, and I can prove it. Every single one that they've made, the answer is, don't trade on the exchange if this issue really excites you. So let's go down them. Here's their arguments that they've made. Oh, we can't bet against our own film.
Mr. Moore, if you can just summarize somehow.
Okay, sure. Short answer is, on every other argument that they've made, the answer is don't trade. Okay, anti-disparagement, manipulation, insider trading, etc. Every single one, you can just simply say to them, all right, fine, don't trade. Go do it the inefficient way that you've been doing for years. Go continue to do your slate financing. I'd like to answer the concern that keeps being raised about manipulation by the studios. The studios we all know they're trying to manipulate.
Do you want to do that I'll promise. I'll ask that as your first question.
Okay. Well, if I hit my 5 minutes, I don't think I've hit it.
Yeah, that red light over there. Yeah.
I'm just warming up.
We noticed.
Okay. So do I have any time? Let me just make a couple of other quick points.
One
other point. All right. There is no insider trading prohibition on a commodities exchange. This has become a great red herring. It's like, let's get done with this. There's no insider trading prohibition.
Thank you, okay. Mr. Moore. Mr. Swigert.
Chairman Gensler and Commissioners, thank you for inviting us to this hearing today. Appreciate the time. At the outset, I want to thank the Commission for approving our application to operate as a designated contract market. Having worked with Commission staff for more than 11 months and submitting more than 100 documents, we commend the Commission and its staff on their efforts. We believe that the approval was a forceful step in the right direction, and we look forward to the Commission's approval of our product application on June 7th. We believe that our product application represents the very essence of innovation, which the Commission has sought to promote for many years. In my remarks today, I would like to focus chiefly on why our product offers a useful hedging tool for the institutional entertainment industry and debunk the myth that box office futures are tantamount to gambling contracts. Despite the objectors' unsupported statements to the contrary, MDEX believes, based on its market research, that a demonstrable need for box office futures and options does exist. We've had discussions with many segments of the entertainment industry, some of whom are here today, about the economic utility of our products. We are here today because we've received strong support from these and other segments for our products. It's no secret that the risk management tools such as futures promote financing and capital investment because they allow those who provide financing to hedge their investments. It is also no secret that film financing has dropped measurably over the past several years. As noted in a recent article that has been provided to the Commission, quote, with studios cutting back on their financing thresholds and Wall Street nowhere close to stepping up to plate, it'll fall to places like Abu Dhabi, Singapore, Russia, and India, along with the reliability of Star Trek billionaires to fill the gap. We do not want to see that happen, and the objectors should not ask the Commission to play party to such an outcome. Our products will allow a host of parties with financial interest in the movie production and revenue chain to hedge the enormous risks associated with producing, distributing, financing, insuring major motion pictures. These groups include original screenplay owners, debt and equity investors, investment banks syndicating a financing slate, talent involved in the film, studios, both MPA and independents, banks and lenders, insurers of talent in movies, theaters, distributors, and co-promotional marketing partners. Ultimately, while we cannot guarantee that our products will be used, we urge the Commission to allow the market to decide whether these products are right for them. Importantly, the contracts that MDEX seeks to list are not dissimilar to other futures and options contracts based on excluded commodities. As the objectors note, the definition of excluded commodity under the CEA does not require a cash market in the excluded commodity. Cash markets, in fact, do exist in many approved futures contracts, including, only by way of example, virtually all economic event contracts and weather contracts. The objectors present to the Commission, however, a straw man argument that an excluded commodity with no cash market would not be within the meaning of excluded commodity if the occurrence is subject to, quote, substantial influence or control of a number of different participants in the motion picture industry. This is not what the CA says. Rather, the CA provides that an excluded commodity includes, quote, an occurrence beyond the control of the parties to the relevant contract and associated with a financial, commercial, or economic consequence. With respect to the first aspect, the occurrence, that is, whether the movie will generate a viable audience and revenue, is clearly beyond the control of the parties. The MPA's own letter cites a study by Professor Thomas Grusha showing, quote, empirical evidence of the arbitrariness of motion picture box office pricing. With respect to the second aspect, the foregoing occurrence is clearly associated with a financial, commercial, or economic consequence, or else the studio would not produce the movie. Studios are not-for-profit organizations. The objectors, which in fact represent only a slice of the entertainment industry, have contended that the reputation and integrity of its industry could be tarnished by allowing trading in the movie futures contracts. This is patently false. MDEX has no interest in disparaging the reputation and integrity of Hollywood. Notably, the objector's broad and popular statement could apply to every industry that has had a product upon which a futures contract is listed. It could apply, for example, to the U.S. government in listing of Treasury futures, the housing industry in the listing of housing futures, the insurance industry, the listing of weather futures, the listing of aluminum futures in the aluminum industry, and the agricultural industry, and the listing of corn, wheat, soybean, and other futures. The notion that regulated futures contracts can tarnish an industry and is tantamount to, quote, legalized gambling is not only outdated, but baseless. It's no surprise that many groups would come at the MPA's assertion that this is gambling and be concerned because of how it was presented wrongly by the MPA to various groups who are not represented here today and voted not to come here today. In designing its product, MDEX has worked closely with CFTC staff to reduce, if not eliminate, the likelihood of excessive speculation and the retail use of its products. MDEX's contract specifications require each contract to be fully funded. In other words, there is no leverage component, thus reducing excessive speculation. We have also imposed tight reporting levels.
If you can try to.
Yep. Like 3 more sentences.
All right, great.
Is that good? All right. At the same time, because they are fully margin essentially cleared by a CFTC regulated clearinghouse, there is no credit risk. In all material respects, MDEX's contracts seek to obviate risk, not create it. MDEX thanks the Commission for the opportunity to participate in this hearing, and we look forward to answering any questions you may have.
I want to thank our panelists very much. I think I made a promise to ask about manipulation in the first question, so Mr. Moore, I'm fulfilling that promise as long as so I can get to some of the other questions.
No one's concerned, I assume, that manipulation, that a studio will try to make a film as high as possible. Duh, that's what they do, right? So the only manipulation could be possible is that a studio will tank its own film. Like that's ever going to happen, right? Because they would kill themselves losing money on the film, losing stock value, and losing goodwill. So that's never going to happen in our lifetime. So manipulation is not a bona fide fear.
I think the question under the Commodities and Exchange Act is whether the contract itself is susceptible to manipulation and whether the exchanges that we oversee can, control for that. I mean, we are an agency. Part of our mission is to promote fair and orderly markets, but it's also to protect markets against manipulation. So it's really about the contracts. Just to clarify.
Understood, but that I've heard manipulation kind of expanded broader than what you're saying. There is no manipulation possible with respect to the reported box office number. It is a self-regulating number. The industry has used it for years. The studios, in fact, pay talent box office bonuses based on box office. The studios have accepted the box office number for many, many years for making hard cash payments to talent.
Can I ask the question that I asked at the end of the last panel? Are any of you familiar with parties who are currently hedging in the over-the-counter derivatives marketplace, on box office? Mr. Burns?
As one of the only pure-play entertainment companies out there, I am sure that there is a fair amount of trading in Lionsgate stock in front of large releases, because one particular movie could be a significant
So they're certainly shorting or going long or short the company stock. Are people using what might be called an over-the-counter derivative, or
I don't know.
Don't know. Does anybody know? No. Do you, Mr. Moore?
Yeah, not on
Right.
films.
Right, not on films.
Yeah, not on films.
Not on films. Mr. Swaggart, do you? No.
I do not.
And to the question I asked earlier, though, do you think that these contracts, if they were on these two exchanges, would be used on more than an occasional basis for purposes of hedging? And if so, by whom?
Want me to address?
Yeah, Mr. Burns. Oh, you have to turn off your mic, Mr. Moore.
I'm going to try to remember that, Sky, okay? I think that actually people would look at this as a hedging vehicle.
And actually use it?
I do believe so.
Mr. Harbinson, do you have a view or no?
I'd like to know where all those people are today, because all I've seen up here at this panel is Cantor, MDEX, and their extended family. 6 of them, and me and Pisano. So we have the industry, 95 or more % of the industry represented. We have the bookies represented, but we don't have the investors who are clamoring for this new and great vehicle here at the table. I'd like to know why.
They're here. That's me. I represent the investors, and I guarantee you that we're going to use it, and to the tune of hundreds of millions of dollars. I also guarantee you that studios will be using this to the tune of billions of dollars, just the same way they use the co-productions, the slate financings from New York, which didn't exist, a market that didn't exist 10 years ago, and $14 billion has been done. They will do it for the exact same reason.
I would have spent millions of dollars as an entrepreneur and invested years of my life in building an exchange that had no business model. I'm not an idiot. And the math that I see today is the extended family, as Steve would like to call it, may be greater than the two who are representing opponents to it. And it's very significant what J.P. Morgan
Yes, I suspected you before my yellow light's on. My last question just is I do think there's something different about this index, which is on an individual movie, than on a whole lot of oil or a whole lot of corn or a whole set of houses. And I raised that the last panel. I didn't know if any of you, not that you're familiar enough with the Commodities and Exchange Act, but just wondering how you see that if you were a commissioner, how you would look at it. It's like on an individual movie. It's not, for instance, on all the movies that are in a quarter.
If I could just sort of give you sort of my view, 35,000 feet, how I would look at this. From the commissioner's standpoint, I would look at every individual movie that comes out in a wide release as an individual company. And the math works something like this. If a movie does $100 million of domestic box office, and domestic is typically North American box office, that's what the totals are. It's Canada and the United States. And what happens is if a movie does $100 million, that means that that movie will do about $200 million in North American revenue. And so what happens is that our business is based upon that. What we do, and I'm assuming that every studio does this, is that we back into a base case.
Since I went over my limit, if you just shorten it up.
Sure, I was just going to tell you that's how I would look at it. So if a movie, for example, that does $600 million at the U.S. box office, a giant hit, that would be about $1.2 billion of revenue just in America and Canada.
Commissioner Dunn.
Thank you, Mr. Chairman, and let me thank you again for having this meeting, because reading a dry seriatim does not bring about the conviction and passion that we're getting from Mr. Harbison and Mr. Moore. So I appreciate hearing this firsthand. I guess there's been a lot of banter back and forth about who's going to use it and is there going to be a critical mass. And as I said in my opening statement, up to 80% of contracts fail. So I don't really see it's the job of the commission to determine whether this will fail or not. It's our job to understand whether or not it falls within the statute that we have to look at, and that is important to me. We're hearing Congress talk a great deal about, as they're looking at the financial reform up on the Hill, and they talk a lot about naked shorts, and that's not finding a congressman in a compromising position or a sequel to The Naked Gun. It is something that is a concern out there about how investors have an impact on an industry, on a company. And I've heard, Mr. Moore, you said that a company is not going to try to tank their own film. But I do have a concern about what do we have in place to ensure that, because we're hearing about how important it is to have these revenues and how important it would be to follow the tick of what's going on in this marketplace for marketing a whole bunch of things in addition to the film in there. What do we have that will assure us that another film company that's going to head with somebody on a box office event are not using these contracts to tank their opponents? And I'd like to hear from everyone on that.
I'll keep it brief this time. We can certainly provide some economic details to the Commission on that, but it makes no economic sense for anybody to purposely try to tank the movie. The contract size is such, it's just not going to make any economic sense.
I'm not talking about their own movie. I'm talking about their competitors' movies.
Yeah. No, I think the positions that would have to be taken relative to the size of the contract and such, it would not allow another person's movie to be tanked. It would take a tremendous number of groups to come together to purposely try to tank the movie, and then to need somebody to take the other side of the position.
And that's on the assumption that this is widely traded and not thinly traded.
Could I just say that no matter what they did, they couldn't hurt the box office on another film. They can short all they want. They can do whatever they want. The public doesn't go to a movie based on whether or not someone has shorted a film or where it's tracking on the exchange. Again, the Hollywood Stock Exchange has been around forever, and I don't know a single person that makes a decision of whether to go to Avatar based on how it's tracking on the Hollywood Stock Exchange. So I don't think it's going to have any impact. I can't imagine anyone even attempting it.
I'm not sure I'm the guy to answer a question like this, but it seems to me that I think you're right. I think that by virtue of the fact that these are events, these are experiences, these are not commodities. This is some sort of alchemy, in my opinion. I think they are subject to manipulation. Whether they would be in fact manipulated or not, I have no way of knowing, but neither do they.
I don't know how a competitor could short another studio's stock and not have that become a disclosable event. And I think that would be an incredibly risky thing for Paramount to explain to MGM or Fox why they shorted a particular movie of their competitor in order to drive down the price. And I agree with Sky. I don't think that's even a remote possibility.
Mr. Chairman.
Commissioner Summers.
I just have a real quick question for Mr. Burns with regard to how you would use this, because the way I understand the contracts on Cantor, Cantor does not allow distributors to participate with regard to their own movies. the chart that Commissioner Chilton put up identified maybe some small areas within a studio that would not have the material non-public information. But if you could just talk about how you intend as a studio to use these products.
Well, we would use it the same way that we mitigate risk right now. So if a movie is going to cost, call it $50 million to make the movie, we will typically pre-sell the foreign rights to a movie to an all-rights buyer in a bunch of territories. Lionsgate is a little bit unique in that we don't self-distribute outside of Canada and the UK. So a market like Cannes, for example, we're selling a bunch of movies right now as we speak and having a good Cannes. I know somebody up here said before that the market wasn't robust, but it's actually pretty good for us right now. So we would mitigate risk that way. So if the movie costs $50 million, we would have $30 million in foreign pre-sales, and that is a way of hedging that risk. And that's just the way that we do business. The same way, as I understand, the Cantor exchange is that we would have a moment in time where we would be able to sell, call it 10% of the domestic box office. So if we said that contract was striking at $50 million of U.S. box office, we could sell $5 million of that, take that $5 million in, use that for print and advertising money if we wanted to do that, or the production itself, and mitigate some risk that way. If the movie did $100 million, the people that bought that contract for $5 would actually get $10 million. If it did $20 million, they would lose $3 of the $5. That's my understanding of how those contracts would work. But again, we hedge almost every one of our pictures because it's all about our base case return. It's not about playing for home runs.
Could I want to address one issue on this because this keeps coming up, and it's this issue of insider trading with his Mr. Chilton's chart. There again, number one, legally there is no prohibition on insider trading on a commodities exchange.
It's in the contract specs.
No, but let me address on Cantor's. It's not in the contract. All it addresses is a firewall, and it's very limited. Is only. And they shouldn't have done this because it's become this red herring that everyone's run off in insider trading. All it limits is the trading by the people who are determining the box office number. It's like the one person at the studio. It's not the whole list if anyone has any knowledge of the film. And what's happened is because of that firewall that they've proposed in their contract, everyone's run off into insider trading land. But they shouldn't have done it, frankly. But there really should be no, just like an oil executive who knows that there's an oil find is allowed to go trade on the oil exchange because that's disseminating information, or a farmer that knows locusts have hit the Midwest, he's allowed to trade. That's not insider trading. That's sharing information, right? And that's how the market should work.
Commissioner Summers, so Commissioner Chilton.
Thank you, Mr. Chairman. Just a quick comment. Again, there's a difference, and the chairman talked about it. It's just that the studio is the people that sort of control this is one of my concerns. If, for example, and nobody's proposed this that I know of, but if you had a basket of films, now I still may have a concern about whether or not there's a commodity in general, but if you had a basket of films, or if you had, the summer movies or something that had multiple studios, then I'd be less concerned about the control of the occurrence. And you're right, Mr. Moore and Mr. Schweiger, about the we don't have insider trading rules here, but we do have conflict of interest rules that are really important to us, and that's what I'm trying to make sure that we're looking at as the studios are potentially, hypothetically going to be involved in this. Mr. Schweiger, I want to go back to what I said earlier because I really do think you have a neat and novel approach, and I am impressed with it. But I keep going back to, we don't know. We have to make a judgment. I mean, Mr. Moore is very impassioned and makes a good point about you would use it. I know there's others in the room who would think they'll use this as a hedging vehicle. But you say you've done market research and you have strong support for your products. I mean, have you provided that to the Commission?
We've provided a lot of information to the Commission over the last 11 months, and we have done market research that would support that. And actually, we've had in-depth conversations with half of the MPA representatives. And
I mean,
this issue did not come up until it was falsely presented as gambling, and there was misinformation provided to the media, and this was taken to Capitol Hill and put into a piece of legislation. There was no issues until this rhetoric was taken out of proportion by people who don't understand the futures commodities industry.
Yeah. Well, like I said, I think a lot of people were sort of, late to the party, and I know you've been doing this for a long time and spent a lot of your own personal money, so I sympathize with you. But we're the ones that make this decision, and I apologize for poaching your Field of Dreams line. I didn't read your entire testimony. It came organically, I promise. But we got to know if it's going to be used for more than occasional. And Mr. Moore makes an important point. And nobody seems more passionate than you, sir. But other than you just telling me, how do we know it's going to be used? Either one of you, Mr. Moore first, perhaps.
You know it's going to be used because all you have to do is look at history. Let's look at the last 10 years. The studios shorted $14 billion worth of production risk. So we know there's a need. They know that they do it. They know that they're not scared of all the arguments that they make against it, anti-disparagement, oh my God, what would the public think if we shorted our film? They have shorted $14 billion of production risk in the last 10 years. In my career of 29 years, I have helped them short about $25 to $30 billion of production risk through various means over 29 years. They do it, they must do it, they will do it, and this is the next logical step for them to do it.
Mr. Harbinson, do you have a response to that? With him saying that the motion picture industry is actually shorting themselves?
Thank you. I don't know that I have. I'm the one to ask about that, but it seems to me that the timing of the short is different with the hedging instruments that are contemplated here versus the current tools that the studios use. And I think that makes a bit of a difference.
My last question, I think it was Mr. Swagger who said, that studios don't have that impact. But, you got to admit, nobody disagrees that their marketing doesn't have an impact on the box office revenues, right? You might disagree with my boxes. You may say, well, they all don't control it. But certainly the marketing of the movie, certainly whether or not a star appears on a show on a Thursday night before opening weekend, right? It has some impact.
Yeah, I think what we're seeking with the exchanges is the same as what the Commission's seeking, is transparency in a very opaque market. And there's a lot of rhetoric that's been put out there. Hollywood is full of smoke and mirrors. And to have a transparent marketplace, the design of our contracts within a 4-week period of time, we don't see where that manipulation is going to occur. Now, if the question is you've got these 6 large studios, and then you've got groups such as the theaters and the groups we announced, who's the person that's manipulating the numbers? The studios are trying to manipulate, to try to encourage you to go see a movie. And the studios aren't going to affect my opinion, yet there's 20-plus websites.
But if you see an ad, how do you find out about movies? You watch the trailers, you watch the ads. This thing I held up earlier, is it the #1 movie in the world and the #1 movie in the U.S.? As Mr. Pisano said, any little bit, they're going to have a competitive leg up. So
They will always attempt to manipulate it to make it as high as possible.
Yeah.
We accept that. They will never, ever manipulate it down.
Okay, well, I'll finish because my time here is up. But, so maybe they're not making it down, but maybe they're going to say, we're not going to put any more money into this dog. Russell Crowe, go on vacation. You don't have to show up for Letterman. Let's not buy advertising for the next week. Not they're going to tank it, but they can make a decision whether or not it's okay or moving, correct, Mr. Moore?
They will never do it based on some attempt to manipulate the exchange. They will always do it for bona fide business reasons. They will always do the best they can to maximize revenues compared to costs.
Commissioner, if I could just for one moment, because I think you're making an interesting point. Typically what happens is that you're buying your advertising, you're putting your trailers out a month in advance. You don't have the flexibility to move that around dramatically, but I do believe that you can change commercials, and I think Sky's right again, where they're going to be looking for the upside. I think actually studios, when this is real money at stake, the studios will pay closer attention to it and will likely pay attention to this to see whether their marketing campaign is working or not. Right. And my sense is it will just basically encourage them to switch out commercials to try to achieve a higher box office. That's what I think would happen.
Okay. That's interesting. I'll follow up, but I'll ask it later. Thank you.
Thank you. Commissioner Amalia.
Thank you. Mr. Harbison, you mentioned your quote was smaller movies would be most likely to be manipulated. Mr. Paisano earlier said he had concerns about the manipulation in the industry. For two people who are focused in the industry, if we're to approve these contracts, where do we look for this manipulation that you've both raised specifically?
I can't speak for Mr. Pisano, but you know, a small film by its nature is fairly vulnerable. If you're asking me how I personally could manipulate a film, what I do when I'm not up here talking to you guys is I negotiate contracts, I organize films, which means leading strikes, and I do from time to time come across and organize low-budget films. So, you know, an unscrupulous union representative could lead a strike and the film would never get out of the starting gate. Now, is that manipulation, or that there's a rumor of labor unrest or a looming strike on the set? Would that affect the value of these instruments? I don't know. I think it would. But that's not for me to answer.
Would you admit that if that was the risk posed on small budget films or small and this of course being hypothetical, wouldn't investors want to have some commercial hedging ability to mitigate that risk of a strike or something like that?
I don't come from the investor side of the business, so I don't know. The industry has been fairly successful in producing motion pictures, producing jobs, producing a surplus of international trade for a long time without this. And you know what you're being asked is to approve this hypothetical instrument in the theory that it's going to make things better. We don't agree.
Well, just like Commissioner Chilton said earlier, how do we know that they're going to be successful? You know, if we're going to approve these in this hearings, an attempt to understand where would they possibly be manipulated, because two industry representatives have now raised the manipulation within their industry concern. And I just want to try to really hone in on that and try to get a better handle. I think you've answered it, and I appreciate that. And I'd like to go on to my next question. There's a Bloomberg story. Headline is Murdoch spreads risk, nets $400 million from Avatar. The quote that caught my attention was quoting Murdoch in a conference call. Jim Cameron's pictures tend to go over budget, Murdoch said in a February 2 conference call. It's very easy to drop $100 million in a hurry on a film. We'd like to lay off a lot of that risk. Mr. Burns, could you kind of speak to this and how the markets operate in this space?
I think that every studio looks at what their return they're shooting for in their motion picture slate of pictures, and I think that, for example, studios will do co-productions. They'll want to have a partner. I think that that's not going to change. I think this is just one other tool that we, Lionsgate, could use, and ultimately all the major studios could use to mitigate risk.
Let me just ask one last question. I've got 3 kids. I've got to find some movies for them this summer. You have any recommendations?
How old are your kids?
11, 9, and 6. And I don't want to have to sit through.
I definitely would not
movies.
Recommend Kick-Ass for them. It's a little.
Yeah.
I would go a little older, or Expendables for that matter. So.
Twilight, Eclipse, if they're girls.
Yeah, they read the book, and I'm scared of that one. Mr. Harbison, any recommendations?
My kids are a little bit older, so we're still in the PG-13 to R range, so probably shouldn't get a recommendation from them.
Yeah, definitely not.
Very good question. Any more? If Mr. Chilton isn't here, I might even be able to. Do we know? Does Bart have any more questions? No. Oh, great. I wouldn't note, though, that there hasn't been talk about this, but there are other parties that could possibly be affected by this. But the retailers, the fast food companies that kind of tie in, all of these other parties that you all probably lay off risk with, right? Do you think that they would use this contract?
I think they could. We're teaming up, for example, in the UK with McDonald's on a movie called Alpha and Omega, an animated movie. They make a huge marketing commitment in advance. So absolutely a promotional partner that has a lot of money betting on a movie doing particularly well, they would absolutely give them an opportunity to hedge out of that risk.
I want to thank the panelists for all their time and energy and patience, because it took a little while to get to this panel. I want to thank the public through May 26th to please submit further comments and keep this record open. Would be very helpful. We're going to move on to one other matter of business, but we can thank the panel and let them move on. I think that we had put this in the Federal Register notice of some way.
Mr. Chairman,
supposed to do.
I'm sorry to interrupt. Did you want to make some sort of?
Well, I will, but I was just going to go through this. Just that we will look at the full record. I think that there's 2 contracts in front of us. I can't remember their dates, but there's sometime in June 7th and June 28th, and unless those are, for some reason amended or delayed, and that this 5 commissioners appreciate this, because we will make whatever deliberation we're going to do is going to be done as a commission. Also on today's agenda is the establishment of the Technology Advisory Committee for the Commodity Futures Trading Commission. This is an advisory committee that once existed, and then for some historic reason the commission didn't continue on, and I thanked Commissioner Amalia earlier, because it still takes somebody to sort of gin us up and make sure that we reinstall this, and I think it's a great idea. But the staff is prepared in order for the commission to do this. We normally might just do this as seriatim, as Commissioner Dunn said, but since we have this meeting, we thought we'd do it here. So this is the actual adoption of a chart order, and it does several things. It reestablishes the charter in finding that the reestablishment is in the public interest. It secondly is an authorization to publish the notice in the Federal Register. Third, it's an authorization to file the charter with our congressional committees of jurisdiction and the General Services Administration. And fourth, a designation of the designated federal officer of the committee, who somebody would be here. But at this time, I'll entertain a motion to approve the order. Maybe I'll let Mr. Amalia do that.
So moved.
Any second?
Second.
Any discussion of this?
We can approve it, and then I just would like to make a brief comment. But
Either way. All right. So all those in favor say aye.
Aye.
Any opposed? Not hearing any. It seems to be unanimous. Commissioner Amalia.
Well, this is an important topic. I greatly appreciate the Commission's support of this. Obviously, with the result of what happened on May 6th, technology is critically important. I look forward to participating in the CFTC SEC joint advisory panel on Monday, and we'll be circulating participant names and agendas for the upcoming July 14th is kind of our tentative date that we've identified for the Technology Committee, and I'd like to get your input on that. Thank you.
Great. So now I'll entertain a motion to adjourn.
So moved.
All those in favor? Aye.
Aye.
The meeting is adjourned. Thank you.